The willing member must be proposed by another member of the Senate, and if the proposition is seconded, the clerk, if no other member is proposed, will declare the officer so proposed to be President of the Senate. Here's what's on the agenda. Debate is to continue on the Dangerous Drugs Amendment Act 2020. The act was passed in the House of Representatives on December 8. Elements of the amendments to the act includes legislation enabling drug samples and photographs of evidence to be received as evidence of large exhibits in court proceedings. The amendment to the act seeks to, quote, give better legal effect to and improve upon 1996 practice directions issued by the Director of Public Prosecutions in relation to the custody of seized drugs. End quote. The practice directions were guidelines for the police and prosecution and could not guarantee acceptance by the defense. Justice Minister Deroy Chuck says the amendments will seek to expand the 1996 practice directions and codify and put them into law. Also, debate is to be continued on the Evidence Amendment Act 2020. And that's what's on the agenda. It should be noted that elements of the day's agenda can be changed or moved. But before we go, here are a few things you should bear in mind if you plan to attend a session at Gordon House. No visitor shall create any act of disorder within the precincts of the House. No visitor shall be admitted to the House without first obtaining an admission card. Visitors who remain within the precincts of the House during a suspension of the session are asked to keep silent. Now over to the proceedings.
Services that make these meetings possible. Specifically our acting clerk, Ms. Curtis, and I ask you to continue to keep the clerk, Ms. Heather Cook, in our prayers as she continues to recover from a difficult period in her life, but we keep her in our prayers. There are just two observations further I wish to make. First of all, one of our number, Senator Janice Allen, over the holidays lost her dad, and in fact his memorial service is to be held tomorrow, so her absence is noted, and we ask that the clerk writes accordingly our best wishes, and we record our condolences on the record of the Senate. As a Senate, we also record our condolences to the family of the late Honourable Gordon Butch Stewart. The tongue of good report has been heard concerning his contribution to Jamaica, and most of us have recorded elsewhere in various forms and formats our condolences to the family, but I would ask the clerk to write on behalf of the Senate, offering the condolences and the recognition of this Senate. The final observation I make is looking at the proceedings in the Congress and Senate of the United States of America over the last couple of days and weeks. I'm struck by the fact that members only speak for 3 minutes, and in some cases 5 minutes. I'm not going to suggest that we adopt it, but certainly make note of the fact that in critical national debates, their restriction really pushes them. Senator Brown, I'm speaking to you. The 5 minute prescription seems to work in the Congress and in the Senate of the United States. So those are my opening remarks for 2021. And of course, it would be remiss of me not to remind us and remind the country, to the extent that people do watch these proceedings, that we are still in the middle of a fight against the COVID virus pandemic. And in Jamaica, we have been extremely lucky because the government has provided the sort of leadership that is quite absent in many other jurisdictions. And we have managed to really survive at a level that is not seen in many other countries with greater resources than ours. So I use this opportunity to remind the country that we need to continue to stick by the COVID protocols and maintain the prescriptions required by the authorities. Statements by ministers.
Mr. President, may I crave your leave just to perhaps as a Senate body, we ought to recognize that we too suffer loss. May I just ask my fellow senators to recognize that you too have suffered personal loss. And in those circumstances, we ask that we all hold you up in our prayers.
Thank you. Statements by ministers.
Just before that, President, we on this side also want to join with condolences to you. It's difficult for you to sit there and express condolences to all of us when we know that you yourself have suffered personal loss in the passing of one so dear to you. I think we would also want to add to that the fact that our youngest senator, Senator Morris, lost her grandfather very recently. So the death has visited us, but we have life to celebrate the good work that they did. And we are sure you celebrate the excellent relationship you had with your mother-in-law. May it please you, sir.
Thank you very much, Senator Campbell, Senator Brown, and all of you who have expressed condolences to myself and my family. I do appreciate it. Statements by ministers.
Thank you, Mr. President. And Mr. President, I know you will forgive me if this once I disobey your instructions and simply add my own personal sympathies and condolences to your family, to yourself and your family as you go through this difficult time. And I also, of course, extend sympathies and prayers to Senator Allen and her family, as well as to you, Senator Morris, for your own family's loss. Mr. President, I stand today to provide a statement on recent developments in relation to implementation of the agreement between the Government of the United States and the Government of Jamaica concerning cooperation in suppressing illicit maritime drug trafficking. Mr. President, Jamaica's maritime space is 240,000 square kilometers, almost 25 times our landmass. This maritime space, this massive maritime space, is unfortunately used by criminals in the guns for drugs trade and other illicit activity, which in turn has a direct impact on our murder rate. Most murders are committed by the gun in Jamaica, and we do not manufacture them. So interrupting this criminal trade is critical. Although we have continued to improve our monitoring capacity through significant investment in vessels, equipment, and training, it is beyond debate that cooperation with international partners is necessary to police these waters. So members of this Honourable Senate will recall the agreement just named, commonly called the Shipwright Agreement. It was concluded in 1997, brought into force in 1998, and amended by protocol in 2004. There was, of course, the Maritime Drug Trafficking Suppression Act, which was brought into play in 1998, and it was amended in January 2016, together with supporting provisions, Mr. President. This comprises essentially the critical elements of the legal framework for the cooperation between Jamaica and the U.S. in the interception of vessels suspected of involvement in drug-related activities. As with any necessary and well-intentioned international crime-fighting tool, Mr. President, challenges can arise in the implementation of the operational protocols. In 2019, allegations were made and a case filed concerning the inhumane treatment of 4 Jamaican men by the U.S. Coast Guard after their boat, the Josette, was intercepted at sea in 2017. It will be recalled that the Ministry of Foreign Affairs and Foreign Trade appeared before the Internal and External Affairs Committee of Parliament in September 2019 to respond to questions relating to that case. The presentation made by the Permanent Secretary was well received and questions answered satisfactorily. As was shared previously, in light of the Josette case, the Ministry engaged its US partners and put forward certain proposals designed to provide more information at the relevant stages of these shipwrighter matters, as well as attendant consular and human rights issues. These proposals, or rather those proposals, which required wide consultation among US stakeholders, could not all immediately be implemented at the time. Mr. President, the latest case to draw attention concerns the Lady Lawler and her crew. We were advised that 4 Jamaican men were aboard the Jamaican registered vessel when it was intercepted in October 2020 and its cargo inspected by the US Coast Guard on the grounds of reasonable suspicion that the vessel was involved in illicit drug activities. Having tested and found that items aboard the vessel contained a type of narcotic drug or psychotropic substance as provided for under the agreement, the 4 Jamaicans were transferred to and detained on the attending US Coast Guard vessel, and the Lady Lawler was destroyed on the grounds of representing a danger to navigation pursuant to the provisions of the agreement, the UN Convention Against Illicit Drugs and Psychotropic Substances, as well as standard maritime practice. The government of the United States submitted through its embassy in Kingston a formal request to the government of Jamaica for the waiver of jurisdiction over the vessel, its cargo, and the persons on board. Following the process provided for under the law, the government of Jamaica approved the request for a waiver of jurisdiction. Mr. President, I must emphasize for members of this Honourable Chamber that the waiver of jurisdiction was granted on certain specific conditions. These were, 1, that the persons would only be charged with offences pursuant to the agreement and that the government of Jamaica would be advised of those charges. 2, that the general welfare, including the physical and mental health of the detained persons, would be ensured. 3, that the detained persons would be permitted, should they so desire, to make contact with Jamaican consular officials. And 4, that the detained persons would have access to legal counsel in relation to any charges brought against them. The Ministry advised the Consulate General in Miami of the men's detention, and when they arrived in the US, that is on US soil, the Consulate promptly made inquiries about their location and made contact with them. The Consulate General confirmed that the 4 men were well and had been assigned legal counsel through the Office of the Public Defender in Florida. The Ministry also communicated with the U.S. authorities through the U.S. Embassy in Kingston, reminding of the above-mentioned conditions on which the waiver of jurisdiction had been granted. On the 15th of December, the U.S. Southern District Court dismissed charges brought against the 4 Jamaican nationals on the grounds of lack of evidence. On the 28th of December, the Ministry was made aware of the dismissal from media reports. The Ministry immediately sought formal advice from the U.S. Embassy on the status of the case, and the U.S. Embassy subsequently confirmed the status of the matter and shared the relevant documents. Our attention immediately turned to ensuring that our nationals were returned home expeditiously. Having learned from our Consulate General in Miami that the 4 men were scheduled for repatriation on the 28th of January 2021 on the regular monthly flight for involuntary returnees, the Ministry of Foreign Affairs and Foreign Trade took immediate action through diplomatic communication with the U.S. Embassy to ensure the return of the 4 men to Jamaica no later than the 31st of December. Furthermore, we affirmed that in a context where the charges against the men had been dismissed, they should not be repatriated under order of deportation. In the interim, the Jamaican Consulate General in Miami was instructed by us to prepare emergency travel documents to facilitate their return to Jamaica. The U.S. authorities fully cooperated in respect of that request, and the 4 nationals arrived in Jamaica early in the afternoon on the 31st of December 2020. These recent developments have again made the shipwrighter agreement a subject of public interest. Mr. President, the agreement remains important to fight against guns, drug trafficking, and related criminal activities. At the same time, the protection of the rights of Jamaican nationals while in a third country is a pillar of our foreign policy. In that context, it has been important to ensure that any legal action and judicial process undertaken by the U.S. pursuant to the Shipwright Agreement is accompanied with action that addresses the human rights and consular needs of Jamaican nationals. Against that background, between the review after the Josette matter and reviews conducted in these circumstances, the Jamaican authorities have identified ways in which operating protocols and procedures by which the shipwrighter is implemented may be improved. One following boarding and search of intercepted vessels, and two relating to the status of nationals from the time of grant of the waiver up to the outcome of any legal or judicial action pursued against them, pursuant to the agreement. More particularly, the Ministers of Foreign Affairs and Foreign Trade and National Security and the Attorney General, supported by an interministerial technical team, met with a wide cross-section of senior U.S. officials on the 6th of January 2020 to further review the operational procedures associated with implementation of the agreement. The U.S. delegation comprised the Ambassador of the United States to Jamaica and senior embassy officials, senior officials of the U.S. Coast Guard, as well as representatives of the Departments of Justice and State. Mr. President, I must underscore that the Jamaican government expressed in very clear terms certain steps key to bridging gaps in implementation, as well as its strong disappointment at the recent developments, including the failure of the U.S. authorities to communicate critical information on the dismissal of the case as envisaged by the agreement. I'm pleased, however, to advise that the bilateral exchange was constructive and frank and undertaken in a spirit of cooperation and mutual respect. Apologies were extended to the Jamaican side by the United States regarding the handling of the matter. Both sides agreed on the following: the importance of the long-standing bilateral relations between Jamaica and the United States, the continued relevance and validity of the Shipwright Agreement to meeting the desired objectives of stemming the narcotics trade and eliminating its contribution to crime and violence in the country, the importance of taking appropriate action to treat with any difficulties which may arise in the implementation of the agreement to ensure its optimum effectiveness, and a commitment to work towards concluding in a timely manner agreement on enhanced operational procedures, starting with a response by the U.S. to suggestions made and questions posed within 2 to 3 weeks of that meeting. In closing, I want to assure members of this Honourable Chamber and all other stakeholders that the Government of Jamaica is resolute in its pursuit of the necessary improvements in the implementation of this important agreement. The Government continues to work to protect Jamaica's safety, sovereignty, and the human rights of Jamaican nationals everywhere. I thank you.
Thank you, Minister.
Mr. President, I want to thank the Minister for the statement. It has been a matter of public interest. And I think it's important for us to get a good understanding of exactly what has happened.
Thank you very much, Minister Bunting. You're permitted a brief run-up and then you ask a question. In fact, 5 minutes.
Thank you very much. That is, in fact, the convention in the House to which the House
to which you are accustomed.
To which I'm accustomed. Mr. President, as a former Minister of National Security myself, I understand the value of the Shipwright Agreement. The agreement forms an important part of Jamaica's national security architecture. When faithfully adhered to, it is designed to guarantee the rights of citizens while protecting communities from the scourge of drug trafficking and its associated illicit drugs for guns trade and the contribution to crime and violence. The two most recent incidents of 2019 and 2020, however, represent egregious violations to the letter of the agreement, Jamaica's sovereignty and citizens' inalienable rights. So the opposition welcomes the government of Jamaica's actions to reiterate the terms of the agreement and condemn action taken outside of the purview of the agreement. as well as the offenses to the human rights of Jamaican citizens. What I really would like to get a better appreciation of from the minister's statement is 2 or 3 matters. The first has to do with the sequence of events as outlined in her statement. In particular, the boarding of the vessel, the transfer of Jamaicans, and the destruction of the vessel. In your statement, the sequence is that took place, and then you mention that the government of the United States, through its embassy in Kingston, submitted a formal request to the government of Jamaica for waiver of jurisdiction. I want to, for absolute clarity, for you to confirm that this is the reverse order, that the government of the United States first issued a formal request to Jamaica for the waiver of jurisdiction over the vessel's cargo and the nationals. And then, after that approval was given, then the further action was taken by the U.S. Coast Guard vessel. That's the first question. The second, Mr. President, is the sort of vague statements in the vague references to improvements in the operation of the protocols and procedures by which the shipwrighter is implemented. And I think it would be helpful, Minister, if you could elaborate on those 2 bullet points in your statement, where you said it may be improved following the boarding and search of intercepted vessels and relating to the status of the nationals from the time of grant of the waiver of jurisdiction up to the outcome of any legal and judicial action. Because given that the consulate in Miami was aware of this case, I am astonished that there was the passage of weeks between the charges being dismissed against the men and the Jamaican government learning of the issue through the media. So just to be more specific, I think the dismissal took place on the 15th, and it was not until the 28th of December, almost 2 weeks, that the ministry was made aware of the dismissal from media reports. So had there been no media reports, perhaps these men would have been languishing in detention up to now. So I am concerned, and this has really not so much to do with the U.S. side, but on the Jamaican side, given that the consulate had been alerted and they should have been monitoring the progress of this case, that weeks should pass and almost, by accident, our Ministry of Foreign Affairs learns of this. And the final question, there has been, let me say, an allegation that the Jamaican government gave permission for the vessel to be destroyed. I gather the Ministry of Foreign Affairs has since said that no such permission was given. Could you just clarify and expand on what exactly happened in terms of that, the original media reports that you relied on said that permission had been granted by the government of Jamaica to destroy the vessel. And I subsequently saw another media report where the Ministry of Foreign Affairs or National Security denied giving permission. But I want to ask, in the circumstances, who is responsible for compensation of the owners of the vessel and also the men who have been dealt with in this manner? Thank you.
Thank you, Senator Bunting. Minister.
Thank you, Mr. President. And Mr. Bunting, Senator Bunting, thank you for your questions and for, of course, not contesting the importance of the matters before us or the cooperation that exists. Your first question, I understand your questions about the procedures because it was only after you brought your bill towards the end of the last term of your holding the position of Minister of National Security. It was that last bill that actually brought the waiver of Jamaican nationals into effect. Before, yes, after, of course, the then opposition asked for adjustments to be made to the bill, which were taken, which were included. But my point being that from its initiation in 1998 up until 2016, waiver was never granted over Jamaican nationals. It was only granted over the vessel and cargo. And accordingly, there needed to be, and non-nationals. It needed, however, new procedures and protocols were needed and were implemented. But this then is actually a process that does not have the vintage of the shipwright. And although it has been largely successful, and many, as in any circumstance, however, any new set of arrangements, however, there are challenges do arise, and there are circumstances which point the way to the need for improvements, and that is what is underway now. Your first question asked about the order in which the incident unfolded, asking whether waiver was not requested first, and that is not the process at all. They request the permission to board, and then they search. And when they search and they find and they test, it is on that basis that they then take action and request waiver. They don't ask for a waiver. You couldn't consider waiving jurisdiction before they have boarded and searched and tested. On what basis would that take place? The request for waiver comes after it has been established by the information provided, having boarded and searched, that this is a set of circumstances which is appropriate for waiver to be granted, and that information is then provided with the request for waiver. And, this is circumstances. There are many vessels who fish freely and who are not intercepted. They have their signal continuing to emit, and they are clearly there in the radar of lawful conduct of maritime activities, and they are not interfered with if they are seen on the seas. The circumstances here and the order of the process, which has been agreed with the JDF, the JCF, the Coast Guard, DPP, AGC, all the stakeholders and technicals on our side, as well as, of course, the Coast Guard of the various districts and the relevant departments of government on the US side that are relevant to this type of process, which they have in effect with many other countries and which operate effectively. In respect of the improvement of operations regarding the information, or rather the process for boarding and search, and as well as as of the point of waiver to the point of judicial determination. I don't want to share all the details because, as you would be well aware, this is about how exactly an interception operation is undertaken and the process by which the process by which not only is waiver of jurisdiction sought, but that the case is built for prosecution of illicit trafficking. And what I will say, though, is that, as stated, We have identified aspects of information and ways in which information is provided that can be improved in order for the Jamaican government to have greater comfort that the process is working at its optimal at all times. And I think we all recognize that even without any question of waiver, without any question of jurisdiction, in any judicial system, every prosecution will not be successful. Every case will not be successfully brought. But one would want to ensure that in cases with the sensitivity of these, that there are sufficient safeguards. And the issue is therefore for us to ensure that safeguards are enhanced. And we do feel that the discussions which we had and the discussions post-Jusset were largely at the technical level. In this case, both myself and the Minister of National Security personally were present for the discussions with the US on the improvements that are needed and why. And I believe I mentioned the AG earlier, but the DPP was also present because we ensured that we wanted them to understand that the highest level of priority was being placed on the requests as they were being placed. Now, on your matter of the 2 weeks having passed between the dismissal of the case and the Jamaican government coming to learn now, this is of concern to us, but it is not of concern to us as much as in the way, rather, that you view it, that is for the consulate to not have been aware, because if you were aware of the number of Jamaicans that are before the court for drug offenses in the US, you would realize that it would be an absolute impossibility for the government of Jamaica to have the responsibility for tracking those cases. The point is, however, that we should have been advised. So we had made the requisite, done the relevant consular interviews by Zoom because of COVID, assured ourselves as to the well-being of the men, ensured that they had legal representation, which is again a part of what is an obligation, and that they were aware of their right to request consular assistance, that is, that they could request that the mission contact them if they had any concerns, which did not, in respect of which we had not been contacted. But we believe that it was not acceptable that we were not advised of the dismissal of the charges. And it therefore is one of the matters that we have indicated must be addressed in the improvements, and we have that is one of the matters on which they are to respond to us within short order. So that is, we understand the concern and we share the concern, but our view is that the responsibilities based on the conditions of the agreement and the conditions on which waiver is granted, that we should have been advised, and the process in that regard needs to be corrected. And then there is a point that was raised about the allegation that about the destruction of the vessel. As indicated in the statement, the vessel was destroyed. Well, let me be clear. The Jamaican government in these circumstances does not specifically authorize destruction of a vessel. The decision to destroy a vessel is taken by the person they call the unseen commander. That is the captain of the ship that does the interception. It is the captain of the ship on the high sea that takes a decision as to how to dispose of a vessel that has been intercepted on suspicion of conduct of illicit activities. Destruction of the vessel on the grounds of posing a danger to maritime activities is a standard best international practice if you are on the high seas. If you are within port, there can be discussion within sight of land, etc. Can be discussion about arrangements being made to carry the vessel inland, etc., or for somebody to collect the vessel. Where you are on the high seas, if the vessel cannot be towed, as these vessels are not set up to be, they cannot be left on the high seas where they will either pose a hazard to passing ships or be liable to be used by other illicit traffickers who come upon it and are able to make use thereof. And therefore, its destruction is not something which is unusual. It is standard international maritime practice. It's contained in the International Convention Against Illicit Drug Trafficking, the Suppression of Illicit Drug Trafficking, the UN Convention. In that regard, it is preserved by the Shipwrighter Agreement, and accordingly, it is not something that while it is not something that we would have been asked, or rather that we would have given permission to do, it is a practice which we acknowledge exists, and it exists in accordance with international best practice. So that is how I would answer that statement, that query, Mr. Senator.
One follow-up on one part of the question you didn't address at all, Minister. You made a comment that there are hundreds of Jamaicans, or, well, many Jamaicans before the U.S. courts for drug-related charges, which may be the case, but the issues under shipwrighter and under deportation are profoundly different in that they involve us waiving our primary jurisdiction over the nationals on the vessel and indeed the Jamaican flag vessel. So in my experience, that was not a large number to track at any one time. So I think it's not unreasonable to expect that much greater attention is paid to the outcome of cases where we waive our primary jurisdiction over Jamaican nationals in particular, or even foreign nationals on a Jamaican flag vessel, because this is not the same as a Jamaican who finds themselves in some state in the U.S. and gets in trouble, where the U.S. government or the state government or the relevant agency will have jurisdiction there. So I really want to press you on that, on responding to that question. And I'm not asking you to divulge any operational issue up to the point of the boarding and search of the intercepted vessels. What I'm asking you is from the arrest of the persons and their processing through the legal and judicial actions, what arrangements does the Jamaican government have to track those few cases so that we can monitor and don't become shocked once again from media reports of what is happening to our nationals? So that's the first thing. And you omitted to answer the second part of my last question, which is where now will the owners of those who have interest in that ship, because it could not just be the owner, it could also be financial institutions, for example, who do they look to for compensation, given the dismissal of the case against the crew?
Well, let me start with that one, because I couldn't give advice as to where a party should seek compensation. I would imagine that persons who feel that they have been aggrieved by the action of any person or state would seek legal advice as to how they could make that, how they could seek such recourse. But it would be, the issue is not one of my personal concern. It is, you are asking me to give legal advice, and that is not appropriate. It's entirely an inappropriate question. Yes, it is an inappropriate question. Mr. President, when Senator Bunting, then Minister of National Security, brought the bill to amend the Maritime Suppression of Illicit Trafficking Amendment Act to this Parliament, to the lower house, and it made its way here again to the Senate, where the now leader of the opposition, Mark Golden, then Senator and Minister of Justice, had to suspend the debate because of concerns raised by this side about the management of the constitutional rights of Jamaican citizens because of the amendment which was being sought without safeguard, without parameters, without limitation, simply introducing the waiver. And the debate had to be suspended to take on board and consider such parameters and safeguards, which have been proposed and inserted. The issue that I would have thought, perhaps then, that you would have considered it so deeply at that time. The matter, I am unable to guide on the matter of compensation. Where any Jamaican citizen feels aggrieved by any decision of the state, we have an excellent judicial system, a legal system, which provides recourse, and guidance should be sought in that regard. And I encourage them to seek guidance in that regard. Regretfully, I am not in a position to give that guidance. And indeed, that you would ask me so to do is inappropriate. Now, it doesn't sound any other way to me.
If I could just, be helpful to the minister, okay? I think she's misunderstanding. I'm not asking her to provide legal advice. Of course not. All I'm saying is...
Minister, are you finished?
No, I'm just trying to be helpful. My point wasn't for the minister to be offering specific legal advice. I'm saying, given how we have seen this play out, and this could have occurred even before the amendment, the 2016 amendment, because we're really now talking about the jurisdiction over the vessel. Given what we have seen play out, there must be some concern to the government of Jamaica in the renegotiations and the development and the identification of these new operating protocols and procedures. There must be a general concern as to what will happen in the case where persons are wrongfully detained, the vessel is as it turns out, wrongfully destroyed, since there was no conviction of anybody or there's no evidence presented of any drug trafficking, then there must be a general concern this could happen again next week. How does the government take into account the financial interests of Jamaicans? And that interest is not only of the ship owner or the owner of the vessel, because that interest, there could be other parties who have interest in that vessel, such as financial institutions. So that is the point I'm making. I'm not asking for any specific...
Thank you very much, Senator Bunting. Minister, you want to continue for me, please?
Sorry?
You're finished?
I was in the final sentence, yes. I was just saying, I just wanted to know, what do these new operating procedures and protocols, how do they address this issue?
Thank you, Minister.
What we are seeking to do is to ensure that the best possible, or rather that waiver is granted in circumstances where the best information possible has been provided, and that the information also provided to the government of Jamaica throughout this process, entire process from beginning to end, is sufficient and timely to ensure that we are able to protect the rights of our citizens. That is the ultimate aim of all of the proposals which have been put on the table.
President.
Thank you, Minister. Senator Brown.
Yeah, I know Senator Bunting has addressed the issue of the run-up, but permit me to, in asking my questions, to appreciate the role of Bert Samuels, attorney at law from the firm Knight, Jr. and Samuels, for advocating on behalf of those people and the Lady Lawler. And I think such advocacy by Bert Samuels is a credit to the Jamaican Bar, of which you are a senior member, President. Minister, I note on page 4, and as one who was, as you are aware, was very active in the Jose issue with those men who said they were treated like slaves. And I challenge you to tackle the bully, and you turn the bully back on me, that you'll survive me every time. But the real bully is about to leave the country now, thanks to some events on the 3rd of November elsewhere. I make no apology for saying that. But in your statement on page 4, and this is a series of questions I have, I asked the first one here. You said the following, Minister: apologies were extended to the Jamaican side by the U.S. regarding the handling of the matter. And I understand, and you could clarify, that the handling of the matter had to do with the Josette, where those did not have to do with the Josette? What handling? Could you tell us what handling, what matters? Handling of what matters you're talking about? No, I stop at that first, and let me get on.
This was in reference to the meeting held on January 6th, which was to look at the improvements that we feel are important to the implementation of the shipwrighter, and also to inquire what could have caused us to not be advised of the occurrence, that is the dismissal of the charges, and for us to have learned of that publicly. It's an obligation for them to advise us, and as I indicated earlier, it was a condition of granting waiver, and it was not pursued. And that was that's a major circumstance that was of concern to us, and they apologize for that, and they have committed to working with us to improve the system, etc. So that's it.
So the apology was not to the treatment of the men, the slave-like treatment of the men. I understand that. No. But how many waivers have we granted since 2016 under the shipwrighter agreement? You recall?
No, I don't recall the number. I would have to check the file.
But it would be fair, Minister, to say that 2 of the waivers granted, the Josette and Lady Lawler, resulted in no conviction in the U.S. court for drug offenses. Would that be fair to say?
Yes, that would be correct.
That would be correct. So that the Ministry of Foreign Affairs granted waivers based on...
Mr. President, just on a point of order, please, on a point of order. I need to correct that, because the Minister of Foreign Affairs and Foreign Trade does not grant waiver of jurisdiction. It is the Minister of National Security on the advice of the Attorney General. We receive the request, we transfer the request. When a decision is made, it is communicated to us, and we communicate it. But the Minister of Foreign Affairs does not grant. And I just want that to be clear, as I know accuracy is important to you.
Minister, thank you, President. Thank the Minister for that clarification. So let me rephrase the question. That the Ministry of National Security and the Attorney General granted waivers for 2 ships transmitted to the U.S. by the Ministry of Foreign Affairs and Foreign Trade. And in both cases, the allegations of drug being found on the boats, the Josette and now the Lady Lawler, has been proven in the U.S. courts to be false. Would that be fair?
I'm not going to adopt your current phrasing, which seems to be an adjustment of what you had asked before. The Lady Lawler case, we're advised, was dismissed, and in respect of the Josette case, the men were charged for other offenses. That is our understanding.
Not jokes.
That is our understanding.
Not jokes.
So, no.
So in terms of, as you said in your statement on page 3, the Lady Lawler, the Jamaicans were acquitted because there's a lack of evidence. How can it be that the government agency, Ministry of National Security, the Attorney General, be accepting the need to waive the rights of our Jamaican citizens to be tried in Jamaica when it is clear that not in prima facie evidence exists? Is it a case that these interceptors are not being truthful sufficient to have their statement stand up in court? Is there a need, therefore, for us to adjust? Just let me finish now. Let me finish. I'm asking the question. Let me finish. I'm asking the question. Let me finish. Because it's about Jamaican workers, Jamaican fishermen being poorly treated. And somebody in the Senate, some of us, have to stand up and defend them. And I am among those who are going to stand up and defend our Jamaican nationals. So, is it that the shipwright agreement is so loose that it allows lies to be told against Jamaicans, on which basis they are carried before the court and thankfully acquitted in the court? Is that the case? And I have some other questions.
Mr. President, if my friend... Well, I just asked my friend to Mr. President, that my reading of Section 16 of the Standing Order would suggest that the line of questioning is inappropriate. For instance, if we look at Order 16.1f, a question shall not contain arguments, inferences, opinions, imputations, epithets, ironical expressions, or...
That's standing order applies. That's standing order applies.
Senator Brown.
Question time.
Senator Brown, the member is raising a point of order.
I would just ask my friend to be guided by that particular provision, or to, indeed, it may be more appropriate for the questions to be...
Thank you very much. Now, may I just point out to the members that that is, in the true sense of the phrase, a point of order. At the same time, I know that the minister can deal with the question regardless of how irregularly it's framed.
Mr. President, I must say I am trying to find the appropriate core of the question, because so surrounded was it by inappropriate elements that it is a challenging task. The Jamaican government acted appropriately in the process, guided by the law, based on the information provided.
Chairman, President, I understand the minister to be saying it's appropriate to have business people, vessels, destroyed at sea because of the laws.
Oh, Mr.
Let me finish.
Mr. President, no, on a
Let
point
me
of
finish.
order. No,
Let me finish.
Senator
no,
Brown.
on a point
Senator
of
Brown.
order.
Senator
On
Brown,
a
1
point
minute.
of order, that is
Senator
not
Brown.
what I said. And that is not an appropriate
Minister, 1 minute.
understanding.
Senator Brown.
Yeah.
Have a seat, please. Let the minister deal with it. Minister, go ahead.
President, his line of argument is entirely inappropriate, misleading, and contrary to I don't know how many standing orders. That is not what I said. I do not know how you can state that understanding. And it's, Mr. President, I do ask that that be withdrawn and struck from the record.
Senator Brown.
Oh, sorry, thank you. I thought you were just dismissing what you said.
The minister is saying that you are misleading the Senate based on your rephrasing of an answer that was given.
I don't accept that, Mr. President. The minister said the government
Senator Brown?
The government acted appropriately.
On a point of order,
Senator
Mr.
Brown,
President.
hold on.
Yeah.
Senator Brown, hold on.
President,
Hold on, Senator Brown.
Mr. President, the leader of government business has made an objection and made reference to the standing order. And you pointed out to the Speaker, Senator Brown, what the issue was. Mr. President, I believe in the circumstances and having regard to his response that he has given, that you need to make a ruling on that matter.
But I was under the impression that a ruling had been made. Senator Brown, the minister is asking you to withdraw a statement that you made, which on the face of it is inaccurate.
You mean the statement that the government acted appropriately? Because I don't think they did. But if that's what is your position, I withdraw the comments that I made earlier. And
Senator Brown has withdrawn the comments and asked that they be struck from the record.
I wish it to be
Thank
clear
you.
that under my understanding, it's my understanding that to destroy the boats, the investment of business people, Senator Webby, where they are falsely accused by a foreign government, cannot be appropriate. Cannot be an appropriate position for a government to adopt. That being said, Mr. President, that being said, because I don't share the appropriateness of destroying people's investment.
Senator Brown, here, I rarely get involved in these discussions. The question of destroying a vessel on the high seas is not a question that relates to anything more than safety of the vessel. Minister said it. You can't tow, and Minister Bunting know that because he was the one that piloted this bill, you know.
And so for safety, we can just...
You can't tow a vessel on the high sea because it jeopardizes the vessel that is towed, that is doing the towing. So the captain make a decision, either to leave it on the high sea or to destroy it. It don't have anything to do with the evidence in the case.
And the compensation. But it suffices, because again, I don't think any of us here would say that if a tile fall off of a building on Harbour Street, that it would be fine to destroy that beautiful building that the UDC constructed, or so that Grace constructed. We have to protect the rights of business people. We have to protect the rights of Jamaicans. So, but Minister, the former Prime Minister, P.J. Patterson, has called for a review of the shipwright agreement, a review which hopefully would tackle the issue of destruction of vessels, a review which would look at the information on which the government acts that lead our people to be arrested and false information placed against them. Does the government of Jamaica share the view of P.J. Patterson that it's time to review the shipwright legislation and agreement?
Mr. President, may I just, my intervention here. My friend as really going into some very, very murky waters. Today marks exactly 5 years since we've had a revision of that particular piece of legislation. And it was
With respect, President, the questions to the Minister of Foreign Affairs, not to the third umpire.
My friend, I'm objecting on the basis...
Campbell, just go ahead, please. You don't have to explain. Just go ahead.
Very well. So what my friend is attempting to do, which is wrong in principle, he's setting out to engage in a debate, which and these standing orders do not make provisions for one to engage in a debate once the minister has made a statement. If the minister has made a statement and he needs clarification, he must point to the exact clarification which he needs. And that's the basis upon which the question should be put, not to engage in a debate. Thank you.
A question was asked about the possibility of review, and I would permit that question if the minister wishes to answer it.
Mr. President, I'm going to answer it by reading from Hansard of the 15th of January, 2016. You would recall today is the 15th of January. Yes, 2021. Madam President, I won't rehash the reasons and thinking behind the bill. It is regarded as essential in the national security interest of this country and the protection of the lives of our people that this measure be put in place as an additional tool in the suppression of international narcotics trafficking and gun running, which are the fuel for significant numbers of murders that plague our society annually. There are practical problems faced by the Jamaican state in combating this gun running and drug trafficking, and this measure is an important measure in addressing that. The words of the current leader of the opposition, Mark Golding, Member of Parliament. And I want to say that those words are an effective answer to the question by Senator Brown.
Mr. President, Mr. President,
Yes, Senator Brown.
I'm getting the feeling, from the applause on the other side that we are repeating the 6th of January, not here but elsewhere. And I've never been one who have been afraid of the night.
That one fly over my head. Answer a question if you have it, please.
I can understand your comment because if it flew over your head, you were not in the capital. Mr. President, the minister on page 4. The minister on page 4. The minister on page 4 of our statement said the following. I must underscore that the Jamaican government expressed in very clear terms certain steps key to bridging the gaps in implementation, as well as a strong disappointment at the recent developments, including the failure of U.S. authorities to communicate critical information on the dismissal of the case as envisaged by the agreement. This is arising from the meeting of the 6th of January 2020. Are you saying you had a meeting on the 6th of January 2021? Because the statement above says 6th meeting with a wide cross-section of U.S. officials on 6th January 2020. That's a typo? All right. If that's a typo, I will not pursue it, because I was going to ask you if the recent... But I'll tell you what I was going to ask her. If the recent development had to do with the Lady Lala or the Jusset, but you're saying this is the Lady Lala. Are you aware, Minister, that there's a prior incident in Jamaican waters between the U.S. authorities involved with Shiprider and the Lady Lawler, which ended up in Jamaican courts in favor of the Lady Lawler crew. Are you aware of that?
The Minister of National Security has spoken of that incident. I am not directly aware of it, and it is one of the matters which had placed the government, both governments, and I believe even our authorities, in a state of concern about how it is that cases are managed. And I hesitate to speak in the way that the Minister of National Security speaks, but it was, when that occurred, the government of Jamaica was accused of corruption because of the disappearance of narcotics when that boat was brought into port. So, into the Jamaican port. So I will say no more, to say that the Minister of National Security has spoken publicly about that matter, and it is one of concern, yes.
Could you tell us whether or not, in giving consideration to the waiver of Lady Lawler with its cargo of oil, yes, sir, the recent one last year, whether or not, in concern the issue, the Ministry of National Security took into mind the potential bad blood between the U.S. authority and the owners of Lady Lawler. Because I raise this, Minister, because the American courts,
Senator Brown, have found the people not guilty. Senator Brown, you're asking a question of the Minister of Foreign Affairs as to what the Ministry of National Security did?
Because the Ministry of Foreign Affairs must convey.
I'm not allowing that question.
You're not allowing that?
No.
Well, are you aware that the DEA, the Drug Enforcement Authority, in their affidavit said that the JDF gave permission to destroy the vessel? Are you aware of that?
I'm not aware of any such matter.
And I'm not addressing you, but was the government aware of the affidavits filed in the case, including that of the DEA?
Did you say that you're not addressing the minister? If you're not addressing the minister, you
just
don't have to respond.
as representative of the government.
You have another question?
Not in our personal capacity. So the question is, whether or not the government of Jamaica was aware of the affidavits filed in the matter, including that of the DEA, which said that the JDF gave permission to destroy the boat.
The minister has already said she has no such understanding. Next question, if you have one, please. Thank you very much. Thank you very much.
Far from acting appropriately, sold out Jamaican interest in this matter. Thank you very much.
My friend, Mr. Brown, again, that's clearly in breach of the standing orders, and I'd ask that he withdraw the comment. Because Mr. President, could you require of the member to state exactly, because if he's making an allegation about selling out, what he's indeed doing is imputing bad motive, dishonesty, and otherwise. And we'd ask that that evidence, or which he is alleging took place, be presented to the Senate.
Mr. President, I also want to just say that if Senator Brown has any sense of that the Jamaican people have been sold out by anyone, he should speak to his current leader of opposition business in the Senate and of the opposition in its entirety, because it is they who brought the law that actually allows for waiver over any Jamaican national.
such a law allowed for discretion. You exercise the discretion.
Senator
you
Brown.
transmitted the
Senator
information.
Brown.
It is you
Senator Brown.
it's your government
Senator
who have
Brown.
sold the people out.
Senator Brown, the shouting is not necessary. I think that the point has been made.
Yeah, but, Mr. President, with respect, I think I know the minister may be feeling uncomfortable, but to resort to those sorts of personal attacks, I think it's really unnecessary. The amendment the minister refers to, while it does allow for the government of Jamaica to waive jurisdiction, the government of Jamaica through the Minister of National Security to waive jurisdiction, it is not obliged to. Each case is examined on its own merit. And they are the ones who decided to waive jurisdiction in the particular cases that we're talking about, not anyone else in either this house or the lower house. They have that discretion in each and every case where a vessel is intercepted. So you must take responsibility, Minister, for your action.
Senator Brown, hello. We can get through this without the shouting, you know.
Yeah, and it must be fair indeed. No, I've never seen her. Mr. President, in the statement that the minister made, or in reply to a question, the minister highlighted that a multiplicity of Jamaicans ply their trade out at sea. And the leader of opposition business suggested that a court proceeding or some remuneration should be considered. There is on page 5, sir, bullet 2, it says, the importance of taking appropriate action to treat with any difficulties which may arise in the implementation of the agreement to ensure its optimum effectiveness. And it continues. My question, sir, is, does the minister believe that a court setting precedent could actually assist and be considered as appropriate action to treat with any difficulties? And if the minister believes that court precedents could assist, would the government encourage, assist such court actions to be taken by those persons who have already been affected, so that precedent could be set to assist in protecting those not yet affected? Mr. President, such a vote, I hear some persons, an individual. But, Mr. President, to encourage, to assist, doesn't end with being the actual lawyer on behalf of the individual. To encourage could come in many forms, and to assist could come in many forms. What I'm saying, sir, is that the learned lawyers on that side and on this side would know that precedent in the court can be used as a protection in the future. And would the government encourage such precedent to be set by assisting or promoting those individuals to take
Minister,
action?
would you encourage such precedent to be set?
Mr. President, I must say I'm a little unclear on the question that is being asked. And I understand that they do have counsel who has made his interest in pursuing matters as far as they may go clear, and accordingly, this is, I have no role in that. I think it is a demonstration of the Senator's lack of understanding of how these processes work, Mr. President, because I don't understand that question. I don't.
Senator Bram is encouraging you to take some instructions from him after Senate. Minister, go ahead, please. Are we completed with this? Announcements? Thank you very much, all. Announcements?
Laid on the table of the Senate today are the following. Ministry paper numbers 1, 2, and 3 of 2021, respectively, entitled Cabinet Agenda Issues, dated October 5, 2020, October 22, 2020, and October 26, 2020, respectively. Annual report on audited financial statements of the Toll Authority for the financial year 2018-2019. Annual report of the Office of the Political Ombudsman for the year ending December 2018. Annual report for eGov Jamaica Limited for the financial year 2019-2020. Annual report of the Auditor General's Department for the financial year 2019-2020. Annual report on audited financial statement for the Jamaica Social Investment Fund for the financial year 2019-2020. Annual report for the Financial Investigations Division for the fiscal year 2016-2017. Annual report of e-Learning Jamaica Company Limited for the year 2019-2020. Annual report for the Tourism Enhancement Fund for the year 2019-2020. And annual report for land divestment for the year 2019-2020.
Thank you very much. Bills brought from the Honourable House of Representatives. Petitions, papers, reports from committees, notices of motions given orally, questions and answers to questions, motions that may be made at the commencement of public business requiring notice, motions relating to the sitting of the Senate.
Mr. President, might I ask for recommittal of notices of motion given orally?
Question is that notices of motions given orally be recommitted. In favor? Go ahead, Minister.
Thank you, Mr. President. Mr. President, I beg to give notice that at the next meeting of the Senate, I will move the following motions. 1, be it resolved that this Honourable Senate appoint a select committee comprising the following members: the Honourable Senator Matthew Samuda, Senator Cavan Gale, Senator Dr. Sophia Longmore, Senator Natalie Campbell-Rodriguez, Senator Peter Bunting, Senator Gabriella Morris, to sit jointly with a similar committee appointed by the House of Representatives to complete the statutory review of the Cybercrimes Act. 2, be it resolved that this Honourable Senate appoint a select committee comprising the following members: the Honourable Senator Kamina Johnson-Smith, the Honourable Senator Aubin Hill, Senator Donald Webby, Senator Sophia Fraser-Binns, Senator Damian Crawford, to sit jointly with a similar committee appointed by the House of Representatives to consider and report on a bill shortly entitled the Customs Act 2020. And be it resolved that this Honourable Senate appoint a select committee comprising the following members: Senator Natalie Campbell-Rodriguez, Senator Dr. Sophia Longmore, and Senator Janice Allen, to sit jointly with a similar committee appointed by the House of Representatives to consider the COVID-19 pandemic and related matters. May I further beg, Mr. President, to give notice that at a later stage today I will move for suspension of the standing orders to take the motions, notice of which I have just given.
Thank you very much. Motions relating to the sitting of the Senate. Motions for leave to introduce bills. The presentation of bills without the leave of the Senate first obtained. Public business.
Thank you, Mr. President. Mr. President, I now move for the suspension of standing orders to permit me to take the motions of which I gave notice earlier.
Members have heard the question. Those in favour? Against?
Mr. President, might the motions be approved?
The members would have heard the Minister and heard the motions. Those in favour? Against?
Mr. President, it is intended now to continue with the matters of the Evidence Amendment Act and the Dangerous Drugs Amendments Act, the debate on which commenced on December 18th, 2020, with contributions from Senator Samuda, who opened the debate, and Senator Bunting. It is intended that we will continue with that debate. And Senator?
No, I think Senator Sinclair intends to speak now.
Yes, sorry, I was just indicating that it is now proposed to continue with the debate. I understand that the next contributor will be Senator Charles Sinclair.
Who said that a while ago, Dan?
Yes, can you imagine?
Encouraging me, eh? Thank you. Thank you very much, Mr. President. You see, you're just colorblind today, eh? Mr. President, the Evidence Act is one that has been in existence for quite some time. In fact, 1843 when you look at it. And over the many, many years, it has gone through several amendments, and the amendments have been all done in order to try and meet changing circumstances and to facilitate the efficiency in receiving evidence with a overall view of obtaining justice. Mr. President, sometimes as practicing attorneys, when we see amendments, and especially when we sit in the private bar, we tend to see these amendments as one that is giving advantage in a lot of respects to the prosecution. But when you look deeply at it, it is, in fact, not necessarily so, because many of the amendments in recent times, as I said, really goes to efficiency, and it works in practice on both sides. So we have seen amendments made over the years to allow for the admission of hearsay evidence, hearsay statements in both criminal and civil matters, and where the parties in civil matters agree that there is no real contest to the content, the evidence can go in with the appropriate notices being given. And in particular, on the criminal side, we have seen where, for one reason or the other, witnesses are not available. And you know, that was one which came in some years ago when we had quite a bit of murders taking place. Somebody is before the court charged for an offense. And you say, well, if you don't have a witness, then there is no case. But the person would have previously given a statement. There was a limitation because if you had already given a deposition. And I think that that particular amendment would have done a lot, because I don't think any accused person would want to face a trial, especially on a very serious charge, and there is no witness present that you can challenge and probably get something from them that shows that there is some inconsistency, because you can't really question statements. And I believe that that particular amendment would have caused a downturn in respect of persons charged before the court who try to get out a potential witness. There's little value to it in eliminating a witness before a trial. And Mr. President, the Evidence Special Measures Act, which allowed for video evidence, there's amendments that speak to vulnerable people, children, and corroborated evidence and so forth. So several amendments have been done, and it has crossed both administrations. And they have served their purpose in respect to efficiency and ensuring that there is justice at the end of the day. Mr. President, this particular amendment is one which will allow for samples of seized drugs, as in the Dangerous Drugs Amendment Bill, as well as in the Evidence Amendment Bill, which will allow for any other item that is relevant to the case and their images, whether in the form of video, photograph, or the digital images, to be admitted as evidence once accompanied by the appropriate certificate. And the benefits, there are several benefits to it, some which have been spoken about by Minister Samuda. It brings us in par with the other first-world jurisdictions. It removes the uncertainty that exists in trying to operationalize a practice direction long set out by the Director of Public Prosecutions. And from a practical point of view, Mr. President, it allows for the freeing up of storage space which is consumed by a large amount of exhibits. And when we look at how exhibits are stored in many of our police stations, especially those that emit fumes and so forth, and we have been speaking about the ship ride and how it relates to drugs, that is one such. But then you can potentially have other exhibits which can be a health hazard to persons who have to work in close proximity to the areas that they are stored. Removes the possibility of the contraband getting back into the public space, and it removes the difficulty in the transportation of significant amount of exhibits from storage to courts. And you know, sometimes I feel it for our police officers. You see them walking into court, struggling, Mr. President, with huge containers of contraband, which will be necessary for the presentation, and only to take it there to hear that the matter is adjourned to another date. So it would have proven futile. And as I spoke about earlier, the efficiency contributes to the efficiency in trials. In this particular amendment that is before us, there is declared no disadvantage to an accused once the protocols governing the imaging and certification are followed precisely. And the clauses 2, subsection 3, 4, and 5 speaks to the protocols. So, President, whilst we move in that direction, it is going to be of, it's just not about the amendment. We have to do many other things. Minister Samuda has gone out, but I am certain that he's hearing from where he is. Because we'll have to improve on the forensic capability of the Jamaica Constabulary Force. That will have to be significantly ramped up. To require training of the personnel and provision of trained officers across the various divisions. What you find sometimes now is that different parishes, different divisions have to be sharing the same forensic persons. So in St. James, and there is something that has to be done in the parish of Trelawney, you have to find persons moving from one local to the other. And that in itself creates issues. It will require the provision of equipment of the highest quality so that images captured adequately reflects the objects that are being captured. And that again contributes to fairness in a trial. In addition, the issues that deal with disclosure, and disclosure as persons who practice in the courts is something that is critical. Failure to disclose appropriately on time are things that can impact upon a trial. And we'll have to see to adequate resources being provided in that regard. The paper on which it has to be disclosed, the disc, and I want to suggest, importantly, the replication of color. Because what I have seen in practice is that you get copies of the various things that are taken, and you get it in black and white. It may not be adequate to meet if it were presented in a live situation. So in order to replicate in color, the necessary resources will have to be in place for the highest quality, as I spoke about earlier. And courtrooms will have to be improved so that the images can be appropriately displayed during a trial. So in addition to the amendments that we are putting forward in respect to these two bills, there are several other things that have to go hand in hand, and we cannot delay in respect to ensuring that they are done. Mr. President, efficiency of trial, what we have seen in recent times, and that these bills will contribute to it, and is that we have seen improvement in our courtrooms right across Jamaica. In fact, in 2018, I had a note that spoke about the investment that was being done in respect to the improvement, over $800 million by this administration in respect to the improvement in the Court of Appeal. Buildings, additional courtrooms will be provided, and the improvement to the registrar of at the Court of Appeal. In addition, we have seen significant improvement in many of our parish courts, and I must commend the Minister of Justice for placing tremendous emphasis on that impacts upon that. And the Chief Justice himself, his staff, court administration must be given our highest commendation. The Chief Justice reported in respect to the clearing of cases over the past few years, and it goes towards the input that has been made in respect to how judges operate and how court staff operate in respect to clearing cases, so that the efficiency, as I said, will be overall improved. I have some specific concerns, though, Mr. President, in relation to the bill. And if I were to look firstly at the Dangerous Drugs Amendment Act, bill, and in particular Clause 2, Clause 2(4)(b), which I would require some clarification. In that clause, it starts out, the Director of Public Prosecution shall, and if we were to move to B, unless it is impracticable to do so, cause the taking of the evidence of the drugs for the purposes of subsection 7B(1) and 3 to be done in the presence of the defendant or the defendant's legal representative and an independent observer. My first concern, because words are important. What is the importance of using the words unless it is impracticable to do so? I have a concern with that. And if the words are not important, and I don't believe that they are, it should be eliminated from the bill. Because I want to know who is going to determine whether what is impracticable or not. Mr. President, if you leave those words here, to me, my interpretation, and I see Senator Motley also shaking her head in agreement, persons may come to different interpretations of it as to what is impracticable. And I cannot imagine any circumstance that could bring about such a situation where persons referred to could not be present. It does not require the presence of the accused person. It says the defendant or the defendant's legal representative. So if the defendant is in custody, and in custody at a particular place that he cannot be transferred, his lawyer can be there. So I don't believe that those words are necessary. Mr. President, the issue of fairness to the accused at all stages of the prosecution of a matter, from investigation to trial, is paramount and should be honored. It is my opinion that it would be unfair to an accused, except where he deliberately avoids being present, for the action proposed to be done outside of it, to be done in his absence. Mr. President, it is the state seeking to gain the benefits of this legislation nothing save and except the deliberate act of the accused should be accepted as a reason for him not being present personally or by his legal representative and independent observer. And I'll get to the independent observer in a moment. So, unless there is good reason that can be advanced for the words, unless it is impracticable to do so, to remain, I'm appealing for its removal. As far as Roman numeral 2, under the said clause 2 is concerned, it is my recommendation that the reference to independent observer be deleted. I have been given a particular reason why it is there like that. But then I'm putting out my opinion, and if there is comments that can be made in that regard for it to remain, then so be it. I'm suggesting that it be replaced with the reference to a justice of the peace. Because it then comes down to several other questions. Who determines who this independent observer is? Is it the DPP, or is it the DPP and the accused person? That does it. And you can get into potential debate, because one may recommend a particular person as an independent observer because it does not identify who that person is. There's no definition as to who can fall into the description of an independent observer, so it is not made clear in the bill. So if it can be made clear and we have a classification of persons who I can comfortably agree with, then the term independent observer gives me some concerns. That is clause 2. And this is really a general comment. On page 2, the Evidence Act refers to, you have clause 2, but it is referring to the Principal Act, section 50, which reads that whereby virtue of any law, anything is seized with or without a warrant by a constable. And it brings me back to the whole issue of warrants. And then again I ask, why in drafting the bill they included with or without a warrant? Why does not leave it out? Because in our jurisdiction and under our jurisprudence, and we have drafted several bits of legislation in this parliament, across administrations too, that refer to the need for a warrant. But Senator Brigham, warrant or not, and the evidence is relevant, the evidence goes in. So it makes me ask a question. Why when we are drafted, we put in warrants, the need for a warrant to do an act, but then our jurisprudence says that regardless of the existence of a warrant or not, once the item seized is relevant, it goes in other jurisdictions. If you don't have a warrant, then whatever you seize is suppressed. It makes me ask a question. And then I go to our Charter of Rights, which probably gives many persons, including attorneys, a lot of concern. Because in our Charter of Rights, and in particular Section 13J, which speaks to the privacy of the home, privacy of family life, the privacy and protection from search of personal property. It causes persons to have conflict because you're saying your Charter of Rights speak to you having privacy, and for that privacy to be set aside, that there should be some objective way of getting it done. And to obtain warrants, you obtain warrants with the justice of the peace after they hear from the person who seeks to effect the search of an individual. So it creates a little conflict, and when we write legislation and do legislation, then how do we explain it to the persons who are out there, the layman who says, but my Charter of Rights says this? And it sometimes put the police in conflict with the citizen, because they turn up at somebody's yard and say, "Where's warrant?" They get into a conflict, because it is written into the legislation that you need a warrant. But then the action is done many times without it. So it is just that I'm putting it out there. There is no necessary need for an amendment, because an amendment, pardon me, an amendment or not in this really doesn't help us. I'm just putting it out there for us to start a conversation. In our jurisprudence, there's really none. And I can tell you that I have seen cases that have been before the courts that in even obtaining the warrant, blank warrants have been signed and then filled in appropriately. So you don't go before the JP and get it. We have some law enforcement officers who go there with a blank warrant and then it is filled in. I call that corruption. But then you get it, you go in and you do whatever you have to do, etc. in that process. And there's no recourse for the person whose property or person is searched. So those are my concerns. Mr. President, I'm going to digress a little bit. And it is caused by comments which were made. In fact, I was in the President's chair on the last occasion when we had this debate. And the leader of opposition business went into comments in relation to a particular judicial decision and the SOE. And Mr. President, subsequent to that, and the comments which were made, other comments were made in the public space, and I consider those to have been very unfortunate, because it was in response to the Honourable Prime Minister speaking at a prayer breakfast, and he himself had also commented on the SOE. He made comments about it. In our last sitting, leader of government business had raised a point of order in relation to the comments that were being made by Senator Bunting. He went ahead, proceeded with his comments. But you know, Mr. President, I have great concern. And as I said, it is unfortunate. Mr. President, if one were to, because the comments that you made, Senator Bunting, was to the Honourable Prime Minister having an affinity to suspending the rights of citizens. And Mr. President, if one were to review the record of the Honourable Prime Minister Andrew Holness and the Jamaica Labour Party administration, now and in the past, and to review that of the leader of the opposition business and his administration, the hypocrisy contained is glaring. Mr. President, it was the Jamaica Labour Party administration that introduced into the Jamaica Constitution the Charter of Rights to protect the rights and liberties of the Jamaican people. It was in that charter that required the state of emergency to get 2/3 majority in both houses to be extended. And it was the decision of the collective that caused the extension. So when it was done in the lower house, it was done with the support of the opposition. When it came here, it was done with the support of the opposition. So collectively, Parliament agreed for the extension of the state of emergency. the Jamaica Labour Party, even with the comments that were made earlier today, because a lot of the comments that were made earlier today, in response to the statement that was given by the minister, spoke of rights and constitution and so forth. And we heard them over there. The Jamaica Labour Party introduced INDICOM, Mr. President, for the protection of the rights and liberties of the Jamaican people. As a result of that, police fatal shooting of citizens is at its lowest today. Mr. President, in respect to the SOEs, there was training of security forces in the area of human rights to ensure that the rights of the Jamaican citizen was protected. Mr. President, where I am from and where states of emergencies were introduced in specific areas, unlike when it was introduced right across the island, the entire island of Jamaica. It was introduced in specific areas, one such area being St. James, where I'm from, where when we reflect between 2012 to 2016, the murder rate was increasing at 20% year over year during that time. We got to a point of 345 murders. And having regard to the state of emergency, Mr. President, it was reduced, and it is today lowest in 17 years. Mr. President, the affinity of the Honourable Prime Minister is to the protection of life and citizens and the liberty of the law-abiding citizens of Jamaica. Mr. President, the state of emergency was welcomed by 80% of Jamaicans. And when you look at what the purpose of the Constitution, to serve, protect the people of Jamaica, 80%. Mr. President, we heard of, and I spoke about hypocrisy, because when I reflect on authorities that have been decided in our courts, when we look on authorities, and I will make reference to them, one Shorendi Quant against the Minister of National Security and the Attorney General of Jamaica in 2015, a decision of our courts. Mr. President, in that case, the Minister of National Security deported a foreign national who was present in Jamaica but was deported by order of the Minister.
President, on a point of order, sir. On a point of order.
Sorry, Senator.
I believe the specific case that the member, Senator Sinclair, just raised.
I recognize you. Go ahead, Senator Brown.
Yeah. Is a matter that is still before the court. And consistent with the position adopted last week and before, matters that are before the court ought to be dealt with in a certain way. And I fear the member is contravening that. And I bring that to your attention. And I serve notice that I want to be as wide as Senator Sinclair when I get up to
you always are. Senator Sinclair being an officer of the court, no doubt is well aware of the regulation.
Well, Mr. President, I will give a response to that. I don't know what aspect of what he's saying is present before the court, because there's also a report that says the Jamaican Security Minister withdraws appeal court application. So we are dealing with what transpired in respect to this particular matter, and it was appealed, the minister withdrew his application.
Your response to the point of order is that it's not before the court.
What I am commenting on is not before the court. So, President, because when we speak about rights of persons and we seek to make ourselves out to be pious, then, I mean, I'm not calling anybody's name. So, President, person was ordered to be deported by order of minister in spite of a court order being in existence to prevent deportation and to have the individual brought before the court. One must bear in mind that anyone present in the island of Jamaica is entitled to the protection of the Constitution. And one of those rights being an almost unfettered right to appear before the court. The unlawful deportation deprived the man of his said right. And when his counsel sought access, further efforts were sought by demanding costs of $1.5 million to be deposited in the court. And Mr. President, I have the ruling in respect to that decision.
Speaker's
Yes,
time has expired.
so finish.
Mr. President, the Speaker's time having expired, propose that we allow him additional time to complete his presentation without abusing it.
Thank you, Senator Bunting. The question is that the Speaker be permitted time to complete. The question is that the Speaker be permitted time to complete his presentation.
Mr. President,
those in favor?
Mr. President, pardon me?
Against?
Mr. President, I have not called anybody's name. But they say when you throw a stone in a handspade. But you know, Mr. President, you know, what was said here, and authorities here too, but I just took out the relevant part. Paragraph 95. No reason was given for his detention or deportation. Justice Goldsmith's order to have him appear before her was also ignored. Further, he was deported while her order staying his deportation was extant. Court orders are to be obeyed. It would seem to fly in the face of justice that the appellant should be deported by the minister, either in flagrant disregard of the court's orders or as a result of his negligence, as it was his duty to oversee the deportation and be required by that party to provide security for costs in order to access the court. You know, when I hear the references to the affinity and casting these aspersions on somebody who has sought to protect the right, and then when I do the research and consider what was done, then it gives me concern and I speak of the hypocrisy in it. There's also another authority, Mr. President, one of Claudette Clark, administratrix of the estate of Keith Clark, against Greg Tingling and others, decision made in 2020, where two justices had to remind the then Minister of National Security that his decision to issue the certificates of good faith at the time that he did, and in the circumstances that he did, and in the circumstances of this case, was unconstitutional because it was manifestly unreasonable and unfair. The minister, having signed the good faith certificate some 6 years after the incident and four years after the proffering of the voluntary bill of indictment, is, in my view, so unfair and unjust that it cannot be seen to be in conformity with the Constitution. So, you know, when we come here and we speak to the rights of persons, and I heard it coming from over there when they were seeking to pose questions and make statements in relation to persons and how we are the persons on this side that want to not protect the constitutional rights of people, I have serious concerns about the hypocrisy that is spewed in this place and comes from over on that side in particular. When it suits you, then you make your comments. I am certain, Senator Bunting, I'm certain that when you were there and you were grappling with the situation, these things that you would have done, which the court spoke about and ruled Mr. Bunting, speaking to you being not in conformity with the Constitution, you thought you were doing the right thing. All right? For further reading, I direct those diligent in research, Senator Brown, to read paragraph 13 of the said authority. Mr. President, the hypocrisy which springs from that case is so blatant when one recognizes that the minister, the subject of that ruling, was acting under regulations contained in a state of emergency. Regulation. Acting under, so guess what? You at the time thought it suited you. For whatever reason, you were prepared to act under it. And then you come here and make the comments that you make.
Mr. President, Senator
Similarly
Charles
worded.
Misleading the Senate. No.
What is the point of order, Senator Bunting?
The senator is misleading the House. He said that I was prepared to act under the emergency powers regulations of that time to empower the security forces to carry out that operation which led to the incident in question. I was not the minister then.
I didn't say that. I never said that. I never said that.
1 minute.
I never said that.
Your administration was in power.
1 minute.
You brought that state of
Senator
emergency
Sinclair, 1
into
minute.
effect. Those emergency powers regulations were of that side.
Senator Bunting, that's very interesting information, but it is not a point of order. Continue, Senator
And I
Sinclair.
did not say that, Senator Bunting. I never said that. I said you were prepared. You were prepared to act under the state of emergency regulations. Instead of saying, no, I am not doing it because I consider these state of emergency regulations to be unconstitutional. Right. You were prepared to act on it and gave those things. And the court had to turn to you and say that it was not in conformity. Your action, your discretion, which you had, Senator Bunting, you had a discretion as to whether you would grant a good faith certificate or not. And you exercised the discretion at the time you exercised the discretion under state of emergency regulations, which you say are unconstitutional. You gave good faith certificates. Well, the court spoke to you in that regard. And that is the hypocrisy of which I speak. So, Mr. President, there's a popular Jamaican saying, made popular by the cutting razor, Peter Tosh, when he says, if you live in a glass house, don't throw stones. And if you can't take blows, brother, don't throw blows. Mr. President, Senator Bunting raised a question. Mr. President, Senator Bunting raised a question as to what has the government done or is doing post-SOE. I am confident that today, when Minister Samuda closes, Minister Samuda, as he promised at the last sitting, that he will respond appropriately in that regard. Thank you very much, Mr. President. Thank you very much, members.
Thank you, Senator Sinclair. Senator Scott Motley.
Going to debate on the amendment.
Mr. President, in the Standing Orders Committee, we have a saying that when the justices agree on a matter, you better watch out. On this occasion, I'm not quite sure, though, that the agreement is as wide as it normally is, because for a moment there, I had to question myself as to whether we were analyzing the conduct of the leader of government business and his commentary. I'm so sorry. Minister, Minister, by now you know no malice intended. I asked for that one. I asked for that one, President. I take my blows. No, but seriously though, I was extremely concerned as to the turn that this very significant debate had taken. But that is a matter for another occasion. Because they say in Jamaica, same knife that stick sheep, stick goat, and so on. And in law, they say there are precedents which are well established. But I have to say, Mr. President, that in relation to his observation on the Dangerous Drug Act, and particularly on his remark as to the effect of the amendment to Section 21A, the insertion of 21A, I too was deeply concerned about the clause that gave the Director of Public Prosecutions the right to give the defendant not less than 7 days' notice of the application to take the sample or to authorize the destruction unless it was impracticable to do so. I'm speaking to the impracticability clause. It involves a level of subjectivity which is not ideal for legislation. I might think that it is impracticable if the rain is pouring. The point is accepted. And similarly, the independent observer. I'm suggesting that if you keep independent observer, then you have a list of persons. But I'm suggesting that for full clarity, you might want to ask that a justice of the peace be inserted instead. Because do remember that the Minister of Justice, Minister Chuck, has embarked on a program to expand the amounts of justices of the peace. So you can't, the previous concerns of unavailability of justice of the peace really don't meet it. But Minister, I will leave it to you to later to address it. That was my main concern about the Dangerous Drugs Act. And I must say quite freely that my concerns about the way in which the Evidence Act has been worded has been accentuated by recent developments. And I remind you what exactly the Memorandum of Objects and Reasons in this regard says to. It says a decision has been taken to enact legislation to amend the Evidence Act to provide that in any case where a thing is seized as evidence, a sample or image of the thing may be taken by or under the direction of a constable, and B, for the sample or image so taken to be received in evidence and have the same probative force as the thing would have if proved in the ordinary way. And that is where I get concerned. Because a thing is anything. When you look at the Oxford Dictionary definition, it's anything. It's a very, very, very broad definition. Because it's everything. Because nothing has been sought. It has not been attempted to be defined. Not in the principal bill, in the principal act, or in this bill.
Everything else may
it says that the sample of the thing can be taken. And then it says an image, whether in the form of a video, a photograph, or other digital image of the thing. Minister, I saw a video of the disturbance, I use that word, on Capitol Hill. And when I saw the police officer who was subsequently named as one Eugene Goodman, I was appalled by his conduct. I thought he was running away from the mob. I said, what's wrong with this man? Why is he taking no action? And I couldn't figure out why he would run away, then turn and face them, back them off, then run away again. And it was just inconceivable. His actions could not be explained with any logic to my mind. And then I learned what his intention was. And his intention, as he has been applauded for, was to protect the senators and to lead that mob away from them. And it brought home to me so forcibly how misleading images can be, depending on the angle, depending on the circumstances, depending on the quality. Now, I want it to be clear that this is not an objection to the amendment. This is a request for some safeguards to be put in place. Because unlike the Dangerous Drugs Act, which requires that when the sample is being taken, that a defendant or the defendant's legal representative and, as it presently reads, an independent observer be present, there is no requirement in the Evidence Act which governs everything, anything and everything. It is that for the purposes of the section, in proceedings for the offense concerned, a signed certificate stating that the person signing took the sample or the image pursuant to the subsection is a constable or took the sample or image under the direction of a constable above the rank of superintendent, and in the case of an image, certifies that the image is a true image of the thing. There is no need in this legislation, Minister, for any independent person, whether an attorney, the defendant, a justice of the peace, or anybody else to be present while this is being done. And I respectfully submit that this is unjust, it's inappropriate, and it defeats the very purpose for which this amendment is being done. Because part of which is the reason why this amendment is being done is to ensure that the courts can function more smoothly, that there are less opportunities for adjournments, that cases can be dealt with as expeditiously as possible, so that the public can feel that justice is in fact being served and it does in fact reside in the courts. And there are too many instances of people taking the law into their own hands because they do not believe that the justice system serves them. We have to protect the rights of the accused because we operate on a presumption that a person is innocent until proven guilty. And what do I suggest? I suggest that when this image is taken, it must be in the presence of similar provisions as in the Dangerous Drugs Act, that the attorney, the defendant, or some other persons be present, that there be agreement as to the image which has been taken, and that an affidavit be signed by all persons there present that there is an agreement, and that this be attached to the image along with the certificate. You see, Minister Samudo, let me tell you, we defense attorneys love loopholes like this, you know. Senator Braham has not spent much time in the criminal courts, but somebody of his ilk understands how it's done. We're going to tie you up in court for hours cross-examining about this matter here. because you don't have the additional, you don't have that barrier of saying, no, but it was agreed to. Persons were present. We're going to take a different approach, and we're going to go behind how the type of video you use, how it was recorded, who recorded it, and from what angle, but we're going to find a way to ensure that we do our very best to represent our client, reflecting a lot of time which is going to be used up in cross-examination. It is true that the court can require the person to come and give evidence. And it is true that the prosecution might ask the person to give evidence, and it is true that the defense might ask it, and therein lies the rub. Senator Campbell is well aware of what I speak.
You mean the third umpire?
So I am suggesting that another close look has been taken of this. And it's the strangest thing that my views were actually reinforced by the minister's statement this morning. Because in that statement at page 2, the Jamaican men, it is stated, were aboard the Jamaican registered vessel when this was intercepted in October 2020, and its cargo inspected by the U.S. Coast Guard on the grounds of reasonable suspicion that the vessel was involved in illicit drug activities. Having tested, and I think they use a special test, narcotics, Minister, remind me about the name, a NIC. They use a special test on board, and that special test determined that it was a narcotic drug or a psychotropic substance. So here we have this is a scenario that we have. On board this vessel, if it had been in Jamaica under this Evidence Act, the mere fact that it was a constable or somebody higher who certified that is what would be tendered in evidence. As it turned out, this was simple straight gas oil. And that is why the cases were dismissed. And it is my submission, Mr. President, that one must learn from the circumstances around them and learn from seeing what else is happening. And that this case, which took place, which was brought to light after we adjourned this matter, should now impact the way in which we are crafting this very significant piece of legislation, especially as the definition of thing is everything and anything. Thank you, Mr. President.
Thank you, Senator Scott Modley. Senator Bryan.
Mr. President, I would wish to say a few things.
I'm noticing that you and your nephew seem to play that kind of tag thing. You are not here when he speaks, and he's not here when you speak. I don't know what's going on.
Yes. Keeps family harmony. Yes, I did. Mr. President, the general intent of the two bills, I agree.
You have another microphone. Can you use your, Senator?
No, I don't. Under the new system, I'm only allotted one. But the general intent, I support, Mr. President. Initially, when my colleague, Senator Sinclair, and latterly Senator Scott Motley, suggested that the wording and remove the phrase, unless it is impracticable, I was a little concerned about simply removing it, because we all live in Jamaica and we all are lawyers in Jamaica, and things can be made impracticable. And therefore you do have to have some provision for situations where it is impracticable. And I think that the best way to deal with that is to strengthen the notice provisions that the accused person would receive, and if he has a lawyer, a lawyer. The challenge that we have is that when you seize large quantities of material, there is a challenge of storage, and it's a fact. And many times, by the time the matter comes to trial, that's another issue, the delays and so on, the specimen or the potential exhibit deteriorates and sometimes often disappears. And so therefore the rationale behind having a piece of legislation like this, to me, is quite clear. So the question is, how do I fashion it so that the accused person is given the best protection? I don't think that the answer is to remove the impracticable discretion or position, but to strengthen the notice provision and the presence of the independent observer as best as we can, and preserve and understand that a situation may happen that there is some impracticability and you will still need to proceed. I have no difficulty, but I understand the system, and if you don't have it, you could be tied up indefinitely and cannot use the benefits of this particular piece of legislation. In relation to the thing, somebody sent me a WhatsApp asking me if I knew that a thing is everything. And while Senator Motley do have her supporters. They like to watch your Senator Motley. I don't know about Senator Brown, but if I get a WhatsApp when he gets up, but so one of your supporters asked me the question, and I was just reading it there. Yes, and I agree, but you see, it is a situation where it is not only dangerous drugs that fall into this category that you may need to preserve it, and therefore you need to have that privilege as well. But at the same time, some of the safeguards that is good for dangerous drugs, I suspect, would also do very well for the thing, whatever that thing is. So that is not an unreasonable position. I want to point out, though, that the courts do have a challenge generally across the system in preserving exhibits. It is not only on the criminal side. On the civil side, where the exhibits tend to be paper-based, most times, there are times when I remember doing a case as a young lawyer where it was a number of shoes. You know, they have the matter of trademarks where the police would raid for counterfeit. There was a name that young people used to call counterfeit goods, which I don't recall now, but it made it sound very good to have. But when they seize counterfeit goods, you may have it in the civil courts, it could be in the criminal courts. They have to keep the shoes. In the particular case was shoes. Various well-known brands of shoes that were not genuine. And there were hundreds of them. Suffice it to say that when I came in the matter was when the appeal was, there was a conviction and there was an appeal, and I was assisting the appeal 5 years later. Not one pair, much less 1 foot of the shoes could be found. The Court of Appeal wanted to inspect to see if some of the allegations made and the findings were reasonable, but they couldn't be found. They couldn't be found. So there is a general problem in terms of storage in the system. And indeed, you'd have thought that paper would be easier to store, but even paper, well, that's right. Even paper, you have a problem, especially when it comes to appeals, because, of course, sometimes the appeal will take some time to get on. And in that time, the paper exhibits, they are lost and so on, and are destroyed not only by human hands sometimes, but by animal hands. If they have hands or mouth or whatever it is they do, rats and other vermins that destroy these things. And so I think that the Minister of Justice and the Chief Justice speaks about, yes, yeah, the person was acquitted on appeal. Anyhow, the Minister of Justice and the Chief Justice, they speak about the digitization of the court. And I believe that that should be pursued rapidly because it would assist on the civil side with the storage and the being able to retrieve, especially paper exhibits. And also, if you had a system where you could take samples or photographs of physical exhibits on the civil side, that could help as well. So when we talk about exhibits, of course, is evidence. And of course, when you give evidence, somebody ought to take a note of what the evidence is. On the general civil side, the judge takes the notes, and the lawyers will do their best to take notes as well. As a person who never really take very good notes and rely on other persons, note-taking is a very important part of the court system, especially when a matter starts today and is concluded 2 years from today. We will notice that we have a problem in the parish courts because, of course, again, the judges tend to take the notes there as well. And if you have an appeal in the criminal side or the civil side in the parish court, you have to get the notes of the proceedings. Those notes could... I have had situations where the presiding judge retires or leave the bench and the notes are never produced. So what it brings me to is that, and I understand that this is a very expensive process, but your appeal is a part of your right to justice. There are many persons who are acquitted on appeal, and their case on the civil side, it is reversed on appeal. So you have to bear that in mind. And your appeal ought to be heard in a reasonable time as well, so that you cannot have a situation where an accused person or on the civil side a defendant or a claimant wait 6 years or 7 years for the production of notes. That sometimes happen because, of course, many times the sentence would have already been served. And so as we consider reform as to evidence and so on, and the preservation of evidence, which is our potential evidence, we should also aggressively look now to reach the stage where we use all the technology to generate, I would not necessarily say real-time evidence, notes of evidence, but within a reasonable time so that people can get their appeal done. It is hard. It is hard for you to win an appeal. You haven't been sentenced to 1 year in prison, and you served 1 year and then is acquitted. There's no compensation for you to get under those circumstances. So that we now need, and I know that the minister is considering it, and they are working on it. They have tried the system where they have taken the oral evidence. It doesn't work that well, and I know that the expenditure to put in a system where the notes are produced. Because what happens is that the note taker, the stenowriter, takes her notes. They used to have male stenowriters, I am told, in the times past. And then that stenowriter has to go away at some point and prepare and translate the notes. But that steno writer may do that case this week, but next week she has to go to Clarendon to take another set of notes. And as a result of that, it piles up and gives a challenge. My understanding now is that you do have other persons that are doing the translation, apart from the one who takes the note himself or herself, and that then speeds up the delivery of the notes. And it sounds very simple, but I'm probably a little blasé, but the point is, it is heart-rending to those who are at the end of it, when they cannot get their notes because, and if, especially after that, that they are acquitted. I have known persons to abandon their appeal after a certain time, and of course they leave with a sense of being aggrieved with the system. Senator Motley suggests, and I agree with her, that we have to discourage people being aggrieved with the system. And so as we look about evidence and the preservation of exhibits which will form evidence, I think that we should also take the opportunity now to see how other issues are to be dealt with in our system, to improve it, to ensure that the delivery of justice is seamless and that the people feel that it is working in their interests. I congratulate the Minister for his efforts and urge him to look at these other matters that I have raised and the modifications that were put to you today in this debate. Thank you, sir.
Can I just make an observation and ask Senator Scott Motley and Golden, and, well, Senator Bram to a lesser extent. Senator Campbell, am I mistaken in saying that there is already common law authority for a judge to act, for example, in a drug case on the certificate in the absence of the exhibit? There is, you know. Anyway, I'm going to get the information shortly. I've just asked for it. Because, you know, you members may recall a number of cases where ganja turned into peas, on another occasion where the police were saying that rats had eaten out the drugs from... So I think there's already a common law right to a lot of what is being...
Mr. President, that with ganja, it's not all ganja that is captured by the Dangerous Act, Drug Act. Is it the male or the female which is the dangerous one?
I think so that there is authority for the judge to rely on the certificate.
Yes, the certificate. I didn't understand that that is what you were saying.
Senator Brown.
Chairman, President, thank you very much, sir. Let me start by agreeing with my friend, Senator Graham. I didn't agree when he introduced a case elsewhere about chicken sexer. Leave me and Ronnie alone. But I do agree with him that in respect to note-taking in the courts and note-taking beat in Parliament, and now I see the government is going to rely every day that the Senate meet on some unsought report of what took place in another place where Senator Bunting sat. It is so important, and I speak as the spokesperson and the public service for the opposition, that we reopen training of steno writers. We need to broaden the pool for Parliament, pool for Services Commission, pool for the Supreme Court, and we want to extend that to the parish courts, and the pool for the Industrial Dispute Tribunal. Again, we demand so much of these writers, but we give so little to them. And I join you, Senator Braham, in pointing out this deficiency, and I hope it can be addressed very soon, because they have served us loyally, they have served us efficiently and effectively, and I believe we need to make the plea for them, since they can't speak for themselves, or they can't speak as loudly for themselves as need to be done. And so I raise that. Second thing, Mr. President, is the issue of samples of evidence. I'm not sure, Senator Samuda, whether the taking of photographs and so forth is going to lead to a retention of samples, so that if people want to be able to test for themselves or to challenge the certification, there would be a sample available. We well know Senator Scott Motley raised the question of that famous case between male and female ganja, which led to the acquittal of people way back. And so a photograph can't tell us whether or not it's a set of male or female ganja. The photograph will not be enough. And so we need to consider the importance of maintaining samples. For example, President, you would be aware that 20 and more years after, people are being acquitted. The work of the Innocent Project in the United States, through the rematching of DNA samples. People get convicted for murder, face death row, but it turns out that they were not the person. In some cases, the only reason why they are charged is because they're black. We know of the famous case in Jamaica with the Diane Smith case and the importance of that ear sample. If that ear sample is not there, but a photograph, how can the defense, how will the defense be able to do the testing to show, as in that case, it couldn't have been Shorty? Right, the third umpire? It couldn't be Shorty. When you check the video and the trajectory of the ball, it couldn't be Shorty here. So it's important that in making these modifications, because the state has failed, I'm skipping that one for life. Because the state has failed to put in the system of storage and so forth, we now come to more expediency against the accused. Accused are oftentimes too poor to get the quality representation that Shorty was able to get on the second time. Much of it pro bono. So I thank people like Earl Witter, Queen's Counsel, for the work he did on the Shorty case. So as we rush to make things more easier for the prosecution, we must have regard for the poor people, who are the ones who inevitably, or in most cases, are the ones being charged. So having regard for the value of reviewing of DNA evidence and so forth, having regard for this thing called the thing, Senator Samuda. The thing can be anything, can be everything. But the thing here frightens me. The thing here frightens me. And I think we need to get a better, it's not even defined. It is the common usage of the word thing. And we need to pause and see if we can find a more restrictive approach. What about the Igla cell in downtown? We take a picture of the things we took from the igloo, and what we do? We destroy them afterwards. I'm not going to the chicken sector. We destroy them. So I am concerned about that, and I share all the points made by Senator Scott Motley and the other senators who have spoken to this. And I urge the government not to rush with it. Two other things I want to say. The Dangerous Act says regulations are going to come. Dangerous Drugs Act. Regulations are to come. Mr. President, if there's urgency to this, I don't think it is as urgent as the Road Traffic Act, which we passed in 2018 November. We couldn't get a week delay in the passage of that bill because they want to get rid of the disorder on the road. But the regulations after 2 years is still not before us. And the act is looking like a stillborn baby, while the carnage on our road increases. So I urge the government to make haste in bringing the regulations under this bill, and in so doing, pull along the regulations under the Road Traffic Act as well. Mr. President, when you left the chamber earlier, I had quipped that you should stay away from the chamber because I wanted to address the points made by Senator Sinclair while he was in the chair. He spoke about that there's no affinity for authoritarianism. And he blames us, the parliamentarian, for a bill introduced by the government. Because we wouldn't be debating it and voting on it if the government did not introduce that bill, or those bills. But Senator Sinclair, in going on the attack against Senator Bunting, forgot certain things. And I just want to quickly and close by repeating this.
Senator Brown, you think Senator Bunting need you to defend him?
No. It doesn't need me to. But fairness.
Because it would be a first.
But fairness requires that I speak. Fairness requires that I speak. I will recall, Mr. President, I will recall, you know, if you had brought some of your guavas, I'd be happy. Next time. It was on Twitter. Yeah. I will be finished before the 120. I'll be finished before the 120.
I was just about to inquire about that because you're
I'll be finished before the 120. I just have a few points to make about the affinity for authoritarianism. It is the affinity for authoritarianism that led to the Senate letters, the so-called letters of resignation that the court found to be unconstitutional. It is the affinity for authoritarianism that led to the NIDS bill being passed and gutted by the court on the basis of being unconstitutional. I well recall, Mr. President, Senator Knight being suspended by the Senate because he dared to ask for more time, he dared to take a certain position on the Bail Act, which was passed by that government, which show an affinity to authoritarianism, and the court struck down as unconstitutional the Bail Act. And finally, Mr. President, before the 120 is upon us, how can I forget? Infringe, abridge, and abrogate the Constitution. And I know today my friend Senator Braham is not going to rise on a point of order because those were the words of the current Attorney General of Jamaica. Yeah, but not to infringe, abrogate, and abridge. And Mr. President, let us be clear. The affinity to authoritarianism, I must say it's not unique to Jamaica. We saw the effect of it just last week on the 6th of January in the United States. Mr. President, thank you. I take sleep and mark death. And I take the death of that policeman, sick man, to be the result of those who have authoritarian tendencies, who are prepared to do it. And I go one step further, Mr. President. Yes, who are prepared to act unconstitutionally. I go one step further, Mr. President. Senator Scott Matley spoke about the policeman Eugene Goodman. May I suggest to the tourism interest minister, yeah, we're going to finish before that. May I suggest to the tourism interest that they consider offering Mr. Goodman and his family a week's holiday in Jamaica. It will allow us to get some publicity, much more than the minister image being in Times Square. Much more than the minister image being in Times Square. Invite him and his family and show our support for democracy. And show our support for democracy. Because we have led the way in our democratic processes. We must pull our friends up north who wish to be the poster child of democracy to show that our way is the better way, and they must not be quick to jump and criticize people in what they call SOL countries. We have shown that we have a better way, and we must side with those who stood up for democracy in the United States, against the insurrectionists, against the domestic terrorists, and against a president who some in this chamber applauded. He has not been good for Jamaica. If you take the break now, I'll close right up.
Mr. President, the time being 1:20, might the Senate be permitted to sit beyond 1:30 to complete the business of the day?
Members would have heard the question from the minister. Those in favour? Against?
Minister, I close simply by saying the affinity for authoritarianism must be rejected. It's real. It can't be hidden. And that there are some things to be done in the regulations. Let us not just pass the bill, Senator Samuda. Let us bring the regulations soonest. Let us also, as I say, the Road Traffic Act, because the authoritarianism, the lawlessness that is on the road is on your watch. It's on this government watch, because it is this government that has failed to bring the road traffic regulations into being. May it please you, Mr. President.
Thank you very much. Thank you, Senator Brown. Minister?
Thank you, Mr. President. And allow me to start by thanking colleagues for their mostly constructive contributions to the debate. No, you soon see the direction of my exclusion. I also see, Mr. President, that your mood from the celebratory season has carried over as much latitude was granted to the debate, Mr. President.
Again, I was distracted.
No, I see that your mood from the celebratory season has carried over into the new year as much latitude was granted.
It's a little rest that I got.
You look better for it, Mr. President. So, you know...
That is what is correctly called brown nosing.
I hope at least it has been successful, President. But, so, the debate focused on the companion bills, primarily on the Dangerous Drugs Act and on the Evidence Act. And I think all persons would have had a chance to review the proposed amendments that were circulated. I will make one point before, just so that there's time to mull it over before we get to committee, because the point would have been made, I believe, by both Senator Scott Motley and Senator Sinclair, if I'm not mistaken. In subsection 4B, related in the Dangerous Drugs Act, related to unless impracticable to do so, the intention is that we will take an amendment. It will read in subsection 4B of the new section 21A, delete words unless impracticable.
Senator, hold on. Just direct me again to the section.
Page 3, Dangerous Drugs Act. Page 3, first line. So dealing with the housekeeping matters first, President. We will, the amendment will be in subsection 4B of the new section 21A, delete the words unless impracticable to do so, and B, insert subparagraph 2 next after the word representative, the words unless the defendant or defendant's representative fails to appear thereafter, note is given in accordance with paragraph A. All right? Now, that is the primary, I think, request for amendment that I will be accepting this afternoon, but I'll speak to the other points raised. I think the amendments that would have been circulated give adequate time for review, and I don't think the government can be accused for rushing the debate, considering it was suspended and time given for review. And I'll go through point by point from my notes from colleagues who presented. In Senator Bunting's initial presentation, he did raise the issue, and I made sure to review it again this morning. Does the evidence, his comment was related to the Evidence Act and whether it does go beyond the issue of drugs solely in terms of how we will treat evidence. And it does, and the reference to any other act in the Dangerous Drugs Act gives that space. You made significant reference, Senator Bunting, in your presentation to SOEs and to the varying crime statistics. There was at one point where you made the point that even in a pandemic year, as it was classified, you had commentary related to acquisitory crimes. So I took the liberty of pulling the statistics, comparing 4 years under your tenure to the 4 years after, to give understanding to the public of really where we've been going, where the numbers have been going. In the 4 years, 2012 to 2015, let's start with robbery. There would have been 9,634 incidents of reported robbery. In 2016, 2017, 2018 to 19, there would have been 5,026 incidents of robbery, representing a 48% decline, showing that what would have taken place last year is consistent with the steady declines that we have been observing since our tenure. When we look at break-ins, there would have been 10,112 incidents of reported break-ins during your period. There was 4,948 reported break-ins during the 4-year period ending 2019, a 51% decline. Under the issue of larceny, there was 2,081 reported incidents of larceny and in your period, and 626 incidents of larceny under the following 4-year period, a decline of 70%. Now, in two other categories of the reported crimes, and I know you're very familiar with the statistics, two that are serious and violent crimes and certainly abhorrent in any analysis. There would have been, as it relates to incidents of rape, there would have been 3,186 incidents of rape during that 4-year period and 2,120 during the subsequent 4-year period, a 44% decline. In relation to aggravated assault, we also noted a 46% decline when we compare the periods. Now, I only bring these up because they were allowed to stand in the initial debate. All right? And the facts remain, and I think every government that has dealt with the issue of crime, certainly when I go through the Hansards going back to the 1960s, you've had a mixed bag of results in some cases. But when we look at this, what you see is that the ability to bring down, because these are your major categories of crime, we've been successful in all but two. Now, these two are not to be taken lightly, and none that I give us a pass on. At the end of the day, we are at the wheel, and it is our responsibility to ensure that we make Jamaicans safer. So the issues of gun crime, the issues of the incidents of shootings, the issues of murders, no one can take solace in the fact that there were increases when you compare the 4-year period. However, we need to be very cognizant of something, and we need to have debates that look at numbers, look at actions taken, look at the successes or failures of said actions. The year that Senator Bunting, then Minister, would have become Minister of National Security, he inherited declines coming from the declines which would have started in the from the SOE action taken in 2010 and would have continued quarter over quarter until the end of our tenure in 2011. So the trajectory over 6 quarters was clearly heading downward. However, when we took government, and I invite Senator Bunting to look back at the numbers, there would have been increases for 5 quarters heading into the end of 2015. In fact, we inherited a 20% increase in murders, and I don't remember the exact figure on shootings, so I won't count it. Now, he knows my strong support for the use of SOE as a measure to deal with the national security issue that we have faced, and I believe for far too long, without the resolute agreement between both sides in terms of what measures are desperately needed. And I've said, and colleagues who would have sat through our multiple debates in the last term know my position very clearly, that it was indeed late, and that when the numbers surpassed 1,000, it was indeed perhaps even too late at that point. I've even chastised, in looking back at the records, my own side's position taken in the debate when then Prime Minister P.J. Patterson had looked at the expansion of the JDF's powers and how they would be used specifically to deal with the issues of gun crime and gangs. And I don't support the position that we would have taken then, though many years ago. It was a mistake, as I've also said to you, that I think it was a mistake to not support the extension of the SOE measures in 2010. Now, on the point of SOEs and its determination to be made by the courts as to whether it is unconstitutional, and you're firm, you've been steadfast in your position, so on whether or not it is constitutional. But the point made by Senator Sinclair, that based on our Charter of Rights and how a state of emergency is extended, if it is indeed found to be unconstitutional, then both sides of the Parliament will have to look at the decisions we took, because it couldn't have been taken without the support of both sides. And I made a point. I made a point. No, hold on. No. I stand by my support of the measure. I stand by that support, and I made the point in the last term of government that so did the public. And when the measure was not extended in St. James, I made the point in this very chamber that there would have been political consequences. And there was. And it was felt right across the country. Now, on 2 points, as I wrap up that part of the discussion, President, there is a term that my good friend Senator Brown likes to brand about, and I think he's probably summarized it well. I think it would describe what he's tried to label us as for a long time in terms of, what was it, affinity to authoritarianism. I want to make sure I quote you. Yeah, that's the term. I think, if we had heard that term earlier from you, it could have made your criticisms of us much more succinct and saved some time in some of the debates, because I think it aptly encapsulates what you've been trying to say. But I wish to firmly, on behalf of myself, and I believe my colleagues, reject outrightly any such assertion. And you know, Senator Brown, I watched the training sessions that would have taken place before the implementations or the implementation of the ZOSO measures under that piece of legislation, and even before the SOE measures were used. And there was a deliberate attempt to ensure that matters of human rights were brought firmly to the fore for the security forces. And I think it is worthy of acknowledgement, President, that for all the criticisms about SOEs from that side, that it is even with those measures that give extraordinary powers to the security forces that you've had a decline in police shootings, Mr. President, and I think the security forces should be acknowledged for that. But I go further. This administration has done nothing to weaken the powers of Indicom. In fact, it has continued to support its position that brought Indicom into being. We have gone further. We have strengthened independent bodies of the state with increased investment and with support of legislation for things like the Integrity Commission. And further, even existing bodies within the JCF, like iProbe, have been strengthened and investment has been made to ensure they function. Now, that flies contrary and supports my statement that this government does not exhibit any affinity for authoritarianism. However, when we look, Mr. President, because it's a point I feel very strongly about, when we look at history, the same way I can get up and say that our lack of support, in my own personal view, for that bill that would have been brought by P.J. Patterson was an error. You need to, in speaking about affinity for authoritarianism, you need to acknowledge that in our history, there have been 2 such exhibitions of affinity for authoritarianism that have not been addressed appropriately by your side, and that the history demands that you do. One, and Senator Sinclair brings it up because I know it hurts him deeply, is the treatment of the street people in that horrific incident, which we have apologized for. Now, the second incident, and I heard the President, when he would have given his tribute, I'm not sure where he said it, at former PM Simpson Miller, when she was retiring, correct? Mr. Seagas, when he made mention of the 76 state of emergency. There's only been one use of the state of emergency measures in this country's history where it was virtually done illegally, President. So the 2 incidents that display an affinity for authoritarianism have not been addressed. Now, President, It's not that I think in any developing democracy or any maturing democracy, you will not have incidents that the state will make, where the state makes mistakes. But I certainly know, you mentioned Carl Gardens, we came to the Parliament and we ensured we apologized. The Prime Minister apologized for something that happened long before he was born, President, because it is right for the history to do so. Now, I think that puts down, I think, Senator Brown, I'm going to forward you some pages of Hansard notes from 50s with comments being made about the Rastafarian community. I don't think that's a road you want to go down, and I think you should leave it alone. It won't end well. All right? But back to as we dealt with those numbers, there was a request for information as it relates to where we would go in a post-SOE environment. And I'm not sure that we're quite there yet. That will be determined by the courts if it is indeed part of that. But what I think is important to note is that the state has not in any way, shape or form withdrawn from communities. In fact, noting the issues related to the change in arrangements, Mr. President, related to the pulling back of SOEs, the state would have taken some steps that would have been visible. And I think I've heard through all of the call-in programs that I listen to from time to time, the comments of just how visible the security forces were during the period of December into early January, Mr. President. When we note that the state did not relent or did not ease up knowing that we would have been under threat, the state called up the Army Reserve and used where necessary, Mr. President. The state has continued in very tough times economically to invest in the safety and security of its people. And there will be adequate time, both in this upper house and in the lower house, where the steps that are to come will be taken. Because, Mr. President, there is a raft of legislative amendment and in some cases new legislation to come to this house within the next couple of months, not years, that will give ample opportunity. But before moving off of that, Mr. President, I think it's important, just for the record and for the country to be aware, in December, for instance, the police would have been able to seize 64 firearms, Mr. President, through the increased security presence in the field and through the use of intelligence. That was a 52% increase on the previous period. Since January 1, the statistics are published on the JCF website, Mr. Bunting. Since January 1 to January 12, the police seized 41 illegal guns compared to the 19 over the corresponding period in January. So the success and the surge and the success of it are being seen. Now, persons would say, well, why haven't we seen it yet in the crimes related to gun crime, whether murder or shooting incidents? And the truth is, we have not hit that tipping point yet, despite our best efforts. However, I bring to your attention and to the attention both of members of the Senate and to the public watching that for last year, the public should take comfort that though you had relatively flat numbers as it relates to shooting and murders, you had an increase from 33% to 45% in the clear-up rate of these crimes, Mr. President, which is something to be noted. So the persons who would have been concerned for some time are now in the custody of the state and answering the charges, Mr. President, which is critically important if we're to break the back of this scourge. Now, the issue that would have dominated discussion this morning, both because of Mr. Johnson-Smith's statement and because of the bills before us, is the correlation with drugs and the drugs for guns trade. Because we know, and as Minister Johnson-Smith said in her statement, guns aren't manufactured here, bullets aren't manufactured here. But the correlation to the drug trade and the impact that it has on our national security are without, or rather impatient of debate. So, President, the bills before us we believe are critical. They're critical, and members would have mentioned to the efficiency of the courts and to ensuring that the courts function in a particular way, something that I believe our investment program and our priority would be on display. I know that the parish courts right across the length and breadth of the country have received investment and continue to receive investment. I would have seen the parish court in, it is Savannah Lamar, when myself and Senator Sinclair were there for the recounts and the improvements that would have been made. Sorry? Yes, that particular victory. And we would have also, I think just as early as this week, we would have seen the announcement from Minister Chuck, the commencement of the investment in Manchester, the Mandeville Courthouse. So the investment continues. But there is also increased investment in the technology that will allow this efficiency. And I speak to, we've now concluded our pilot with persons appearing for mention dates from the Horizon Correctional Facility digitally, where we had to move very quickly to get that going, even though the project was on the books before, but we had to move a little faster with it because of the COVID issues, and every time somebody left, they had to be going into quarantine. So the reduction of the need for that movement was very important to how we've managed the disease thus far. And we'll speak more about that in coming weeks, but it's a program that we're building out right across all correctional facilities and certainly your major police stations. And when that comes, that will improve the efficiency significantly for the courts, as well as for the security forces who have to manage the movement of prisoners. And that is something that we're particularly proud of, and more details will come soon, President. The other point of note is that in looking at the efficiency of court operations, the Chief Justice, the Minister of Justice, the Minister of National Security have established a committee that first started by looking at the movement of prisoners within to and from the courthouse to ensure that the movement itself was not affecting the efficiency. Those issues have largely been solved. Now, but through the use of that multi-stakeholder committee, many other issues were brought to bear. And we're going through in a systematic way, led by our Minister of Justice, to ensure that the efficiencies of the court are optimized. But there's another layer to these bills. It is not just because of the issues for storage for the courts. It's not just because of the physical space required to hold this sort of evidence over a period. There's a safety element, Mr. President. There's a safety element for those who must guard this evidence, which in many cases is valuable in the trade, and those who must transport this evidence, Mr. President. It would be reckless of us not to proceed with this when we consider the risks for them. Now, additionally, before I take the last 3 points raised about the actual bills as opposed to the width of the debate, I think it's important to note, and you form your own judgments, right? But the facts remain that the vessel that was the source of the minister's statement this morning, and just so that persons are aware, was boarded by the JDF Coast Guard in 2009 for suspicion of drug trafficking within our waters as a single incident. Then again in 2014, the vessel was again the source of a narcotics investigation where 3 persons were actually arrested. Now, we know there have been issues in terms of how that matter has been dealt with, because it has not resulted in the convictions, which should give some concern to how these investigations and operations are carried out. But I think it's important for the Senate to note that the vessel...
Clarification, Chairman, President. Are you saying, Minister, that the 3 incidents result in no conviction for these people? So there's no charge of drugs being found on the boat? Because you see, they're not here to defend themselves. And when we raise it up in this way, the full picture needs to be clear that they were absolved.
Absolutely. And the full picture is, as I said, it does raise a question as to how the investigations were carried out and how the operations were carried out, which is why things like the Dangerous Drugs Act and the Evidence Act must be reviewed and amended, which is why if we find operational issues that need to be addressed, we address them both with our partners and with our security forces. But the full picture includes, Mr. President, that this vessel has been in the middle of drug investigations 3 times, investigations that have been published in the traditional media. So I'm not speaking about anything else that isn't public knowledge. This is public record and has been published that 3 times this vessel has been at the center of narcotics investigations.
Could you move on?
Sorry?
Could you move on?
No problem, President. No problem. Now, I'm responding to what was raised in the width of the debate, since it was such a wide debate. But I take your point, President.
I know, and I didn't like it then, and I don't like it now. You see, you are in a position of authority. The other persons were just speaking.
No problem. Going through comments made, just to make sure I've covered all the points noted. The court's running smoothly. I mentioned, as raised by Senator Scott Motley, the concern about independent observers, as raised, I believe, both by Senator Sinclair and yourself. It is the intention and to deal within the regulations. Now, you can take comfort in the fact that, as Senator Bunting would have said at the closing of his contribution to the debate in December, the Act will not come or will be put into use without the regulations. It can't be. But the issue will be dealt with there, and there are functional reasons why we don't want to limit it just to JPs. And it's not just because the number of JPs are increasing, but there can be real reasons why other qualified persons would be included, and that list will be in the regulations. So we acknowledge the increase in the number of justices of the peace, but that list will be covered in the regulations. Because I've brought up the term regulation, well, rather the regulations, just to note that we are far advanced, and those regulations allowing this to be put into practice will come first to the lower house, then to the Senate, before the end of the fiscal year. So the intention is to have this available to the security forces and the courts before April, so that we can start to realize the benefit of the efficiencies. I noted what you said, and I noticed that your colleague Legal Minds chuckled when you spoke to defense attorneys finding loopholes, because I guess you all immediately would have thought of particular experiences and would have seen the issues. But I believe in Senator Braham's presentation, he gave me some comfort when he told the story of the shoes. And I think with what is to come in the regulations, the loopholes as it relates to how photos are to be taken, stipulating how the videos are to be dealt with, how they're to be stored, I believe that those will significantly close some of those concerns, or loopholes that could be used that make the court proceedings inefficient. So I believe those are adequately dealt with in that space, so I won't touch much on those now, Senator Scott Motley. On the point raised by, I think, more than one colleague on whether or not the warrant or no warrant, Senator Sinclair, that issue doesn't cause any offense. But to note, it is because we've had seizure of drugs and guns and other evidence in circumstances where there's sometimes not a security-led operation. So there would be no warrant in place. So we're not intent on changing that space. You've had it seized at school gates. You've had it in other institutions where it just becomes, where items become visible, that things have happened. So we left that, we're leaving that as is. And I take your point. I believe Senator Brigham adequately also settled the issue of thing, as listed in the Evidence Act. But just to note, and just taking points now from Senator Brown, I support his discussion on steno writers. No opposition certainly from me, and I don't believe any from the state. But the matter, the final matter that you'd have raised, Senator Brown, is not just a matter of easier. The investment and significant investment at a time where funds are, tight, continues to be made in storage and a particular quality of storage, even for the samples, both within the court system and at IFLSM. So IFLSM, for instance, has been the beneficiary of over $500 million of investment, which went into the DNA lab, which would have been a follow-on from that piece of legislation, Senator Bunting. It has also gone into storage of other items which are seized that are now stored at international standards following best practices. So that is an area that, because I guess I have visibility, that I understand the point raised, but I know the investment is keeping pace with what needs to be done for storage in that space. So I have no difficulty in that space, and I believe, well, I know I've dealt with the issue of the affinity for authoritarianism. So with that, Mr. President, I close the debate and ask for a second reading of the bill.
Yeah, just before you did that, I'd asked Council to assist me with the common law principle that relate to the absence of exhibits, and just refer, for those who may be interested, Jadis Singh and Jadis Singh, a 1963 case, and just read for your benefit. In Jadis Singh and Jadis Singh, the appellants were charged with possession of ganja, vegetable matter which was found by the police at the home of the appellants, was analyzed and certified to be ganja. Prior to the trial, the ganja was replaced by grass, which had been exhibited. The complaint at the trial was that the product exhibited affect the safety of the conviction, so the lawyer was saying that because it's not the ganja, it can't stand. The Court of Appeal found that the weight of the evidence, and that there was clear and convincing evidence that what was found was in fact ganja based on the certificate, and this was upheld in a case in 2010 called Salesman. So what is happening here, as I understand it, is that you're getting away from where the evidence is, where the product, the article is not in the court. The common law position is that the question would be one of weight. You're moving away from weight and replacing it with firm evidence where the appropriate steps are being taken. Correct?
Correct, President.
Thank you.
So
I would have preferred a correct from Senator Motley, Senator Sinclair, or Senator Golin.
Rather from the learned Senator Samuda.
Village lawyer. But with that, we conclude the debate, Mr. President, and ask that the bill be read a second time.
Thank you very much. There are in fact two bills, correct? Yes. So let me deal first of all with the Evidence Amendment Act. The question is that the Act, that is the bill, that is to say, the Evidence Amendment Act 2020 be read for a second time. Those in favor? Aye. Against? The ayes have it. Let me just deal with the other one as well, and you deal with both of them, Madam Clerk. And in relation to the Dangerous Drugs Amendment Act, Section 2020, the question is that that bill be read also for a second time. Those in favor? Aye. Thank you, Madam Clerk.
A bill entitled An Act to Amend the Evidence Act, and a bill entitled An Act to Amend the Dangerous Drugs Act, read a second time.
Thank you. The Senate will now resolve itself into a committee of the whole Senate to consider both bills, clause by clause. Okay, let me deal first of all with the amendments are in the Dangerous Drugs Act, correct, Minister? So let me deal with the Dangerous Drugs Act first. I put clause 1 of the Act. I believe there is an amendment, Minister. That's circulated.
Yes, Mr. President, that's circulated.
Thank you. So I will put the, first of all, put the amendment to clause 1. Those in favor? And I put clause 1 as amended. Those in favor? Ayes have it. Clause 2, there is also an amendment to clause 2. Is that correct, Minister?
Correct, President. Mr. Chairman, there is, as circulated, in addition to one I would have mentioned at the closing, which reads in subsection, which is under clause 2, 1, 2, 3, in subsection 4B of new section 21A, delete the words unless it is impracticable to do so, and B, insert in subparagraph 2, next after the word representative, the words unless the defendant or the defendant's representative fails to appear, therefore, after note is given in accordance with paragraph A. Yes.
Thank you very much.
Just a concern, Chairman. If that's sitting for the taking of the evidence photographs is scheduled, but some unfortunate event happened to the legal representative on the way and was not able to attend, that rule out the right of the work of the accused to have his representative present? Or we're saying if the absence occur in circumstances which, for example, just couldn't allow for the attendance, in that case, I'd hope that you're not going to just move and show the right to be present.
No, but you will note that a dimension of independent observer would be there, which would be someone that would be there to ensure that rights are maintained. And I think when the regulations come and you see the list of persons and why we've chosen to go that route, you'd be comforted. But additionally, I don't know of any situation. Sorry?
Can I propose without reasonable excuse? Because there may be a reasonable reason. There may be a flooding. There may be any event that intervenes.
I'm certain Curtis is.
And this is too important a right we're giving up for just leave it to some independent. Because the truth be told, some of these independent are more dependent on the state than independent of justice.
It actually says and an independent observer. It doesn't say or. So what the bill is saying is that it's either the defendant and an independent observer, or the defendant's legal representative and an independent observer. But the way in which you were explaining it a while ago suggests or.
No, I'm not, well, if that was what was taken from me, that's not the intention. But I also want to bring your attention to the fact that the government chemist or any analyst designated would also be present who, you know, are persons with of the highest professional standard, and to be noted, Mr. Chairman, and your colleague senator would be able to verify this. There's never been, since the establishment of IFLSM, any overturn or rejection of the evidence they've provided in our courts. I mean, so you have independent, you have officers of the state, and you have the government chemist. I don't see the concern in the same way you do, admittedly, Senator Brown.
The very name government chemist says to me that the person is beholden to the government. And
No, member, because quite frankly, I know, and other members of the legal fraternity would know where there are cases that the institute have exonerated persons that the state would have put for prosecution. So, respectfully, from their space, I don't, and I'm saying I hear your position. It's just not a position that I'm minded to support.
Thank you very much. So I put the amendments to clause 2. Those in favor?
Just to be clear, Chairman, the amendment makes it a conjunction, and the independent person doesn't replace the legal representative. But you're not taking my point about reasonable excuse for not being present.
No, because quite frankly, I don't see it the same way you do in line with the point you've made, and that's the nature of a debate. We'll agree on some things and not on others. And beyond Chairman, I don't see the prosecution wanting to risk a successful prosecution for that to be challenged. So practically, it's not a position that I expect or that I see taking place. I don't see the seat. So I'd ask you just to put the clause, President.
I have. Those in favor? Against? I think that there is a new clause 3.
Yes, Chairman, as circulated.
Thank you very much. So I put the insert of the new clause 3 as contained on the sheet. Those in favor? Against? Ayes have it. I put the title and enacting clause. Those in favor? Against? Ayes have it. Now let me deal with the Evidence Act. I put clause 1. Those in favor? Against? I put clause 2. Those in favor? Against?
In respect to the thing, has there been consideration given to the points being raised? Because this is really, really so broad.
Said I was accepting an amendment as saying I'd accepted the comments of Senator Brown that I believe should assuage concerns. Senator Brown, rather. So it's not, consideration has been given and significant discussion has been had right across, Ministry of Justice, all of the drafters, Ministry of National Security. We're not minded to accept that.
Thank you very much, Minister. I put clause 2. Those in favor? Against? Ayes have it. I put the title and enacting clause. Those in favor? Against? Ayes have it. With respect to the Dangerous Drugs Amendment Act 2020, the question is that I do report the bill as having passed committee stage with 6 amendments. Those in favor? Against? Ayes have it. In respect to the amendment to the Evidence Act Amendment Act 2020, I do report the bill as having passed committee stage without amendment. Those in favor? Against? Ayes have it. I do report both bills as having passed, and I have to do it individually. I do report the Dangerous Drugs Amendment Act 2020 as having passed committee stage with 6 amendments. With respect to the Evidence Act Amendment Act 2020, I do report the bill as having passed committee stage without amendment. Minister?
Mr. President, I now ask that the bills be read a third time.
The question is, members, that both bills be read a third time. Those in favor? Against?
A bill entitled An Act to Amend the Dangerous Drugs Act read a third time and passed. And a bill entitled An Act to Amend the Evidence Act read a third time and passed.
Thank you very much. Leader?
Mr. President, it is not intended to do any further business today, save that there is a senator who seems that he would wish to find reason for us to to spend more time together. Mr. President, as you said earlier, indeed, it has been our first sitting for the year 2021. Indeed, 2020 had its challenges, but we have pulled through. Let us all remain in good health, of positive mind, and committed to the tasks before us. We had some scuffles today, and there may be scuffles ahead, but let us remain committed to the task of making laws for the peace and good governance of Jamaica. Yes, we continue to treasure and value all the many things that make Jamaica special and that make us proud of our country. And so we work in her benefit to build her grace and our fellowship. So with that, Mr. President, I ask for Senate to be adjourned for a date to be fixed.
Thank you very much, Leader. The question is that the Senate be adjourned for a date to be fixed. In favor? Aye. This Honourable Senate now stands adjourned. I didn't get that. I'm not hearing you. Okay, thank you. Leader has a, quote, small housekeeping announcement.
Sorry, just for the Microcredit Act. It was tabled in the House on Tuesday, and it is part of the AML CFT regime. Very important, and we are on schedule that if it is indeed passed next week Tuesday, it would be tabled here next week Friday to be taken on the 29th. It must be passed in January. So I'm going to ask Mr. Luton to circulate it so that everyone who is interested can start to sensitize yourselves with the content so that if there are issues, you can raise them before so that they can be dealt with. If possible, even at the lower house, so that, I would ask the orderly, if we do have copies now, then perhaps we could be assisted with copies before we leave, because even if there are changes, they could be taken in the lower house so that when they reach us, yes, when they reach us, we wouldn't have to send it back down, which would cause us difficulties. So it's a bit unusual, but just asking for everyone's cooperation on this. Yeah, and if you have issues. Thank you very much, Mr. President.
Thank you very much. This Honourable Senate now stands adjourned for a date to be fixed.
The new NITS bill has been drafted and is ready for review. We want to hear from you. Go to